with all of these incredible mentors, and we hope to continue the relationship with our wonderful mentees today. So put on your seatbelts, and here we go. Yes, and so for those of you who may not know, MVLS really focuses on removing barriers to justice, and we do so through free civil legal help, community engagement, and advocating for equitable laws. We are always hoping to address the huge justice gap in America. Only about 20% of the people can afford the civil legal assistance they need, which leaves 80% of the people at a significant disadvantage. So our vision is for a fair legal system that is free of injustice and equitably serves underrepresented Marylanders. We also are always working toward trying to reduce barriers to justice that are created by structural racism. Just for an example, the high cost of legal services combined with the racial wealth and opportunity gaps limit the ability of many people of color to hire counsel or pursue cases. In the family law context, there are also racial disparities that persist through the family law systems, with some judges, not all, but certainly judges making assumptions about people of color in terms of their parenting abilities or their commitment to children. They may treat Black or people of color litigants differently, and implicit bias certainly comes into play, which is why we would like to talk about implicit bias today. And I'm sorry that this is in the way, and I don't know that I can really go anywhere with it, so my apologies.
There you go.
Oh, great. It's magic. So implicit bias is defined as attitudes, stereotypes, or beliefs that we develop and hold in an unconscious manner, which influence our understanding, actions, and decisions without conscious awareness. And this can affect the way we perceive people based on their characteristics like race, gender, or age. And they can even contradict our explicit conscious values. So it's the way that our brain processes large amounts of information quickly. And it's shorthand. So sometimes this is not at all discriminatory, and sometimes it certainly can be. So what we want to do is create awareness, because acknowledging and understanding the implicit response is really important to people who are informed decision makers, and that certainly includes lawyers. And I just popped these pictures up here thinking that it might prompt everybody's brain if they were walking down the street for positive or negative. People might pass any of these people / lion that was there for a bit, because I think we all know what our brains would tell us to do if we passed a lion on the street, but we may just automatically think a certain way. And this Jennifer Witter can explain implicit bias beautifully. And so I'm just taking a little portion of her conversation to so that she can share with us. There, because I think she did a very good job talking about implicit bias and giving some very real examples. The test that she refers to, you can take the Harvard Implicit Association test. It tests for all kinds of implicit bias. The link is in your materials. She talks about how she took it and she was embarrassed. And there's certainly no need to be, because that is not the goal here at all. The goal is just awareness and being conscious and think about things. And certainly this impacts how we think about our clients and certainly how the court sees our clients. So I just listed a few examples here, but to just think about, how does a court think, how does a judge think of a nuclear family? Or what does the court think a mom or a dad looks like? Or people who are using drugs or recovering or live in multi-generational families? These are all things that where implicit bias can kick in and make judgments about someone before they even have the opportunity to be heard. So there are steps we can all take. The first is to uncover and acknowledge your implicit bias and to motivate to be impartial. And this is in your materials, so I think I'm going to leave it to let everybody go through when you get a chance and just see the different opportunities and ideas that are proposed here on the different kinds of things you can do to start to work on your unconscious bias. And you'll see that in your materials. And just something of note is that working on your individual implicit bias is so important, but it's most effective when it's combined with structural and institutional change. So just a challenge for people to be thinking about, their communities or where they work in ways that maybe they could make a change. So the good news is that the most effective method for mitigating bias is actually part of good lawyering in family law. You're presenting the court with a picture of your client within the context of their community and their family. And so these are all things you want to be thinking about as you're talking to your client, as you're thinking about perhaps your own bias, and then how do you account for that in the courts. And one particularly important way to do this is to learn about trauma-informed lawyering. And I highly recommend, unfortunately, this slide is missing. I highly recommend you visit our website. We've got some amazing trauma-informed lawyering on there. So, trauma can be something that happens to you, something that you witness. It can be a result of living in poverty or within proximity to poverty. It can be part of being impacted by structural systems that are unfair. There it is. I didn't know I did that. Okay, I guess this is a special way that I'm doing this. Sorry about that. So we talked about, here we go, what else can cause trauma. And these are just different ways that trauma shows up. And I guess I want you to think about that in the context of putting your client on the stand. If you're in trauma, you can be irritable, you can have difficulty concentrating, you can be emotionally numb, which makes it telling us, very difficult story, and you're emotionally numb. Is that believable? So these are all factors to consider. And just to share something very quickly, I used to be a public defender at the Parental Defense Division, and I took a training on trauma-informed. I really didn't know any of this. I didn't know the impact that it actually has on people's brains. And my clients were parents who had been accused of abuse and neglect. Many of them had been children in need of assistance themselves. So now their children are being removed from them, traumatic. This causes a huge disruption in so many ways. And then the Department of Social Services gives them a list of 10 things they have to do to get their children back, and checks in with them once a month to see if they've done it. And their brain is formed and shaped differently because of all the trauma. It's like putting somebody in a wheelchair at the bottom of steps and telling them that, okay, we'll be back and we'll expect you to be at the top of the stairs. It's just near impossible. So there are things that we can do, and here's just another list of looking at different ways that trauma impacts our clients. And these are things to consider, again, as you're preparing. And these are reactions to people who have experienced trauma. They get harsher punishments and sentences. There's an assumption that they're not being truthful. These are all very negative impacts of somebody who's already been traumatized. So we've got here some examples of trauma-informed lawyering where we're talking about what has happened to this person versus what is wrong with this person. And this is also in your folder, things to consider when you're getting ready for interviews and court. And some more tips on, oops. Okay, well, I guess, let me see. Sorry about this. All right, I guess that's not, do this, thank you. All right, so these are different ways to prepare. You're gonna explain in advance what's gonna happen, keep your questions open-ended. You're going to validate the survivor's experience and feelings. You know, if they're telling you something terrible, you can say, it sounds like that experience was really painful, and just be reassuring. And I'm sorry, these are some practice tips for dealing with people who are experiencing trauma. And just finally, these are just a reminder to, now that you have the tools, we're hoping you'll stay with MPLS and commit to continuing your training. And please always feel free to reach out, because I'm always available and can also connect you to resources that really have done deep dives and are quite competent in this area. And thank you everybody so much for listening to this presentation. And now I'm going to hand it over to Jessica. Yes, do you want it as your PDF or do you want it as your PowerPoint?
I would say the PowerPoint.
Okay, so I believe this is it. Okay, great. And oh, that's okay. Okay, I'm trying to. Sorry,
it's down there on the board. Oh, okay. The giant thing that says that.
I want to do present, but I'm.
I'll get it.
Oh, you will? Okay, great, thanks.
It's because it's not in it.
Okay, thank you so much. Yay! Computers are not my strong suit.
We'll get you
Not
taken
that
care of.
announcement needed to be made.
Well,
But,
won't get you taken care of. Do you need your phone, Jennifer?
oh, that's great. Thank you. Wonderful. Thank you.
Let's see if I can do two things at once, guys. All right, today we're going to talk about trials and all the stuff we're doing leading up to the trial prep. Mentors, please help me. And I got lots to say. It took me a really long time, so I can't promise we're going to get through all of it, but we're going to try. All right, so today we're going to talk about the new custody factors that came into effect in October of 2025. Briefly about child support, alimony, marital property. We are going to talk about attorney's fees because even though we are in the pro bono world, you are still eligible to ask for attorney's fees. Keep going, Thomas. Okay. We're going to talk about the 9207 marital property statements, which may or may not be applicable in our cases. So I'm going to touch on it pretty briefly. The 9204.2 statement, which is the statement of parenting and custody and access time. We're going to talk about pretrial statements, stipulations at trial that might be beneficial to you or your client and beneficial to streamlining the trial presentation, opening, closing, directing cross, leading questions, introducing documents and objections. The custody factors, they are codified in 9201. They went into effect on October 1st of 2025. They are very similar to the factors that are set out in Taylor v. Taylor and Montgomery County versus Sanders, despite the fact that those factors in those two cases are no longer applicable. I would still encourage you to read those cases and to read any cases interpreting that, because I believe that a lot of our judges and magistrates will be using that knowledge as they apply the new custody factors that went into effect. Part of the new set of Maryland family law statutes also includes a directive that the court must articulate findings on each factor considered. Just a reminder, the statute now takes precedent. The case law helps us, kind of apply it, even though it came previously. Do any of my mentors or my mentees have any experience trying cases under the new custody factors yet? They're only about 6 months old, so.
Yes. I didn't want to answer that, but yes, I have.
All right, can I put you on the spot? Where were you?
Sure. Howard County.
Okay. And what kind of experience did you get when they were going through them?
It really wasn't that different. It's just that they have to comment on every single one. So the end when they're telling you their ruling just takes longer.
It's really best practice under the old set too.
Right. So I didn't really see much of a difference. It was also a short one in front of the magistrate. So it's not like we had a whole lot of time. I think it can make non-MVLS cases much longer if people start to try and over produce evidence for all the different factors.
Yeah, certainly.
I think it's made lawyers, I've tried it in Baltimore City. I think it has made lawyers be better at presenting their cases because they can just go through the statute. And so maybe newer lawyers or not as seasoned lawyers who might not have known the case law as well can just now know they have an absolute outline as to what they need to present.
Yeah. Sarah, did it change how you presented your case? Like from
No,
what you asked in closing?
like she just said with an outline, I've always gone through the factors.
I have too.
Right.
So yeah.
That is literally how I organize my case, and then I decide what evidence I have for each factor and what it overlaps, and
Yeah.
so it didn't really change anything for me. The only thing that was different was that the report and recommendations was longer, and she went through all of the would comment on every single one as to whether it applied or not, whether there was evidence or not.
Go ahead, Thomas.
I have done it also. The one thing I wanted to add, and this is just my own reading of the statute, but it's right there. It's black letter. There's much more of an emphasis on the child's emotional connection and the emotional impact of custody. They're literally, I would say 4, but definitely 3 factors that express that, which none of the previous Taylor factors expressed it. Certainly.
It was kind of implied, yeah.
But this is expressed. And a lot of the times now it's a bigger deal. Their kids' feelings are apparently bigger than they ever were.
So I will tell you, Jennifer, forgive me. I've been terrible at keeping track of my email this week if it wasn't case related. Did you already send out the documents like that?
Yes.
Okay.
Yes,
So
yes.
as everyone will see in the materials that Jennifer sent out, you have the benefit of 2 of my timelines and testimony that I drafted. Please do not let this come back and bite me now that you know what I do. But if you can go through it and you will see that the custody one is from pre-9201, but you can see just as Sarah said, when I tailor my trial testimony, when I am prepping, this is the factor, here's the series of questions. This is the factor, here is the series of questions. And obviously I make it flow much less clinically than that, but it is how I craft my testimony. And when I think about what evidence I'm going to present to the court, so that it is very systematic for the bench when they are reviewing everything and they can kind of check their little boxes and say, yes, I heard about this. Yes, I heard about that. Yes, or no, I didn't hear about this. And therefore it's probably not applicable. So just keep that piece in mind, guys. Oh, that one got cut off. Sorry. I'm not going to go through all the 9201 factors. You can look up the statute. If you haven't read it already, I would strongly encourage you to read it. As everyone said here, it is very much just a checklist of what you need to present to the court and what evidence the court needs to find. We talked about a lot of this. Identify the factors most favorable to your client when you're presenting your case. Don't shy away from the ones that aren't favorable to your client, though. I always try to get out ahead of that because it's better to present the less favorable than let the other side twist it into something negative. I think a lot of times in our pro bono cases, especially when it comes to custody, that can sometimes be very, very important. And I think not shying away from it is commendable from the bench's perspective too, in my experience. I always, when I'm doing my closings, especially, I tie the testimony and the exhibits to the specific factors. That way, again, I'm doing all of the heavy lifting for the judge or magistrate, and more often than not, you make them think less about what they're going to do, and you just kind of tie everything up in a pretty little package, and they're more inclined to just say, oh, I like that option, right? As opposed to letting them get creative, because that's where people get in trouble. Child support, the guidelines in 12-200 section are presumptively correct. Back in, I think it was 2022, I believe that's correct. It might have been 2023, and if so, forgive my typo. They went up that the guidelines are mandatory up to $30,000 combined monthly gross income before taxes, before any deductions, all of those sorts of things. Anything above that is still discretionary, but the top of the guidelines calculation is the presumptive minimum. It considers the child's reasonable needs and the parent's standard of living. I don't know, hold on for 1 second. I think this is important to note. If you have not read the Hauser case, I strongly encourage you to read it. Under Hauser, parents cannot waive child support. The court is not going to just let us get away with these general charges unless the child support guidelines actually support it. It needs to be very de minimis. The child support is a right of the child, not the parent, which is why you cannot waive it. Unanimous or joint parental agreement does not override this. The other thing people need to recognize is even if you only file for custody and your request for relief in your original complaint for custody does not ask for child support, the court is entitled to sua sponte order child support in a case. Now, in many jurisdictions, Anne Arundel County especially, that has always historically been the case. But in many of your other jurisdictions, you know, especially your smaller ones, you know, if you don't ask for it, kind of the rule of thumb was you're not entitled to receive it. That is no longer the case when it comes to child support, especially. I will say from my perspective, and the mentors can certainly chime in, I don't actually think Hauser changes what the actual law was at all. All it did was tell us all that we weren't doing what we were supposed to be doing. Am I wrong?
No, and the judges, was anyone here at the Baltimore County, Baltimore City bar dinner where they had a judge from every county, a lot of the counties, and they all said the exact same thing. It didn't change the law, it just made sure you now follow it.
That goes for judges too.
Oh, I don't,
We're following it.
well,
Not the ones on the.
I don't disagree with you. I don't disagree with you. I think this is holding us to the standard that we should have all been, and by all of us, I mean, the attorneys and the bench, that we should have been held to.
They did say, though, it doesn't mean that there's never going to be a waiver of child support
Yeah,
if it's found to be in the best interest.
correct.
That was something that they reiterated.
And that's one of the things.
Mhm.
There are legitimate reasons to deviate. And the factors in 12-202 expand upon that. It's just a matter of laying it on heavy or laying it on thick when you are explaining why you are requesting this deviation, especially if it's a joint request for a deviation, right? I think as long as you are laying it on very thick, making the record very clear, tying it to, well, this child does travel baseball, for example, and there's $5,000 in additional expenses that another child otherwise might not have had. And therefore, the overall annual child support package is being reduced by this $5,000. I think if you are hand-holding the bench to those deviations, they are going to be more inclined to give them to you, in my experience. And I see you, Erica, shaking your head. So thank you for supporting what I'm saying. The other really hard one that came up last October is this multifamily adjustment. Anybody got any experience with this? Oh, all right, we're gonna volunteer Thomas and then Rich. I don't have any experience trying a case with this yet. I have so many questions, and every time I ask a member of the bench, I get very conflicting answers. So go for it. What's your experience?
Well, I thought it was gonna be much harder than it actually is when there literally is just a drop-down menu on Sassy Calc and you just input how many kids are involved. I have not had a situation where there's been a disagreement on whether or not the payor parent actually has the child in his or her home. I know that's coming. But
Well,
Yeah,
I was just saying, the statute actually says it has to be more than, say, 60% of the time. And you need, and at least from best practice, I already would show, like, here's the lease, who all's living in the house, or show some utility bill or proof that they're living in a property,
but I could.
or who all's living there.
Right,
Well, no, actually, but at least something's better than nothing.
agreed.
And it's usually better, because the problem is you can say, oh, I have a child, like, well, yeah, but it's your child support order, the child, or show me I would show the custody access schedule for their other case, just to kind of show that the person's actually living there, as opposed to not.
Without arguing with you, because this is not arguing with you. For what we do for MBLS cases, I would absolutely expect someone to the other side to put someone on a lease, or many people on a lease who are no longer there, or maybe never were.
Right.
Good luck with that.
And also, it's usually just reduces it, like for one child, it's like $700 or $800, credit essentially. So it doesn't make that much of a difference.
Yeah.
It's like $40-50 essentially on a month child support. To me, the bigger issue is when child support wasn't pled. You have a simple custody case, they're in there for a simple custody case, and then the judge or magistrate's like, well, what about child support? And it kind of looks at you like, what do you mean, what about child support? We didn't ask for it. The parties didn't bring any financials with them, and now you're just guessing and coming up with numbers. That's where it gets more interesting.
We as attorneys should know better. But
When
it's
you're
the pro se parties or the,
when
yeah.
you're in court or you're hired the week before trial,
Yeah,
well,
you're covering something
I hear
like a
you.
limited scope representation, and you're there, and you anticipate the problem, and you say, hey, give me your pay stubs,
And
you're
they
gonna
don't.
need it, and they don't, you're stuck.
Well,
true.
this is also true. Touche. All right, alimony, I'm just gonna touch on this one very briefly. We talked about it a little bit previously. There's the 3 different types of alimony: pendente lite, rehabilitative, and indefinite. We're probably only in the pendente lite and rehabilitative, if at all, in our cases here, but just be aware that they do exist. The alimony factors are set out in 11-106, I believe. And then there are some additional factors if you are pleading or trying to prove or defend against indefinite alimony. The one thing I will always tell people from a court preparation perspective is the court is not bound by any of the alimony guidelines or any of the alimony calculators, but they can assist you in your argument at trial to justify the alimony request that you are making. So if anybody does not have access to those calculators, I'm happy to assist if somebody needs to. I don't know, John, do you know the answer to this? Do some of the law libraries have Kaufman and?
That's a good question. I don't know it, but I could find out.
Okay, if you could do
And
that.
I'll send it to the
I
group.
hesitate to ask another question, given how much you have, but
That's
when,
just the factors. Go
for
for
the
it.
folks who've done this for a while, when's the last time you saw an opposing counsel present those to a court? It's
The guidelines.
alimony
Yeah.
or Kaufman. It's been at least 10 years for me. I haven't heard anyone mention it.
I've seen Kaufman used more in my experience than the AAML. Yeah. I will say in this day and age, I'm seeing less alimony in general.
So for those of you who don't know, can you explain what Kaufman?
Yeah, so Kaufman Kaufman and AAML are both, they're very similar to the child support guidelines we have here in the state of Maryland. They have various different formulaic calculators that are used in jurisdictions across the country that I use them more from this is a reasonableness range when I am asking for alimony or negotiating alimony. They're not binding on the court the way the child support guidelines are. I don't know if I did a really good job of that. Sorry. Was that a good enough answer, you think, Erica?
It's also garbage in, garbage out as far as what you put in.
Well, also true.
And none
also
of the qualitative factors, thank God, are in that.
Also true. So they do have their limitations, right? They're not
Sorry,
monetary.
Thomas, can you say what you mean by?
Qualitative factors?
Well, what you mean by the garbage in, garbage
Sure.
out when the mentees may not.
So when it comes to child support guidelines, like no one, I hope, doesn't disagree on the kid's existence, their name, their date of birth, gross income, but there's a lot more to put into an alimony guideline, like who is primary caregiver, but
Correct.
more so for me, well, the guidelines alimony guidelines do not ask for contributions during the marriage, circumstances gave rise to the end of the marriage, physical and mental condition of each party.
Yeah.
Yeah.
There's a lot of the more subjective factors.
You just can't.
But things like who's the primary caretaker of the parent? Well, that's subjective, arguably.
Income over time.
Yeah, and
It's
income,
either income right now
correct.
or education right now, one or the other.
Correct, yeah. So there's a lot of controlling factors, and Thomas could put in one thing and I could change one single input and you would have a drastically different,
Which is why
output.
there are no standardized.
yeah,
alimony
correct,
Mhm.
correct. But they are helpful in assessing a case, I would say, from my perspective.
I was gonna say, so the guidelines we're talking about, the Coffin guidelines came through the Women's Law Center. So if you would go to the Women's Law Center, look or type in and Google Coffin guidelines, it's about $100 for a license for the year. I think you can, and or so. So you could download it through you could look up the Coffin guidelines, it's through the Women's Law Center.
That's right.
And essentially, right, it just has simple factors. But it's really helpful at a settlement conference or pretrial conference to have run it. It just gives you a ballpark idea. But yes, it does not really utilize any of the 11,106 factors. And it's more based on education or of the parties.
Correct.
And it is very subjective. And most judges would almost laugh at you if you tried to use it. But at least when you're between the attorneys, if there's attorneys in the room, at least it gives you a ballpark idea of what that alimony might be, or if it even is an alimony case.
Yeah.
Or you would use it, say, at closing. You can bring in the alimony guidelines the same way if you were trying to show child support guidelines.
Yeah. The other thing I will say is it does, the Kaufman especially estimates what child support should be based on the input you tell it about who the primary caretaker of one or more children are. The problem is, as the state child support guidelines have changed, they used to be very close in number, the Kaufman alimony guidelines, and estimating that figure, and now it's not so close with the most recent updates to the child support guidelines. So just keep that piece in mind too.
Yeah, so the People's Library has a calculator online for child support. Is that not accurate?
So that one is good up to $30,000 combined gross income. That one's run through, what is it, DHR? Yeah, Department of Human Resources, which is where, interestingly, the child support offices are housed. Structurally, it doesn't make any sense, but that's neither here nor there. But yes, those are the same ones. For our purposes for MVLS, you're not going to need any different child support calculators. If you have cases where the parties' combined gross incomes are above that $30,000 per month threshold, Sassy Calc, the paid subscription, it's like $300 for the year. And it's the same one the judges and the magistrates use, will extrapolate above that $30,000 figure.
Yeah,
So
Sassy Calc is sort of the standard. I think it's easier to use than.
it is much easier, correct?
And yeah, so it's sort of like it gets updated regularly. It's a business a lot, I think. Like one lawyer who's on the listserv I'm on always advertises.
Yes, Stu Grosbein.
But anyway, I was sort of like, yeah, do I have to get this? And it helps if you're doing it.
You should buy.
It is well worth the $300. I will be very candid with you.
It's also available at the law library, but you're not going to want to run to the law library. I just want to say something about alimony, especially with is that I find, and everyone here will say, but a lot of clients come to you and say they want alimony. No matter what, they want alimony, but that is not going to be, there's going to have to be an analysis. So sometimes people have been married for a year, they have comparable salaries, and there's just, I think the word on the street is ask for alimony. So just because a client comes to you and says they want alimony doesn't necessarily mean they have a case for alimony. So that's kind of an analysis and a conversation you're going to need to have. And I'm sure Jessica could probably say more about that, but if that's your experience
Good
as
luck.
well.
Sometimes
Sarah just got one. I'm sure she'll be happy to speak to.
Sometimes you file for alimony against your advice. Let's say that is my
There
answer.
you go. Okay.
Yeah, sometimes you can't talk them off of that cliff, even though you know very well they are not going to be awarded alimony, and then you filed for things with a note that we're doing this against my advice.
And when
So
you're
I,
volunteering, you have to fill out the long form, which is a pain in the butt. You won't get it right the first time when you work with the client. And then, yeah, they have a need, but the other person does not have the ability to pay. With MBLS clients, I think, well, my husband, my wife, whatever, she drives for the bus company, so she makes 60,000. She's got lots of extra money. No, she does not have lots of extra money. She's paying her bills. That's great. There's no extra money.
yes.
And for you mentees, if you ever have a question, just remember one of us in this room. Like, we are happy to have you call us
Yes, and
ever
talk you.
and talk through the scenario to give our idea of what, if it is a valid
Claim.
claim, or also we could maybe help you in giving the verbiage to your client as to why it's not necessarily going to be successful.
With
I
Alan,
had one more thing, Jennifer, which is that, like, when you see the little case descriptions on our portal about the MPLS cases, to this point, someone might say that they're interested in alimony. Unfortunately, the time that we have to spend with people on intake is very brief. Like, we try to keep our phone calls with them under, 6 to 8 minutes, and then they send us the
Wow.
documents. That's what we got, because we get hundreds of calls every week. So we don't do, I just feel like I should put this out here. We don't really have the time to do a legal assessment. And our intake advocates are not attorneys, into like, do they have a legal basis for alimony? So they may be saying that in the case description, but don't assume that we've analyzed that and that we've determined that they are going to likely be eligible for alimony when you receive the case.
That is a great point, Margaret.
Thanks for that.
I will say one of the biggest things in my experience with alimony as it relates to MBLS cases is expectation management.
And we
Learning-
also try not to set any expectations when we are on the phone with them. We're not like, yeah, our attorneys can do that. Like, that's not what we're telling them. We're just trying to get the facts, put it together in a packet, that's kind of the goal.
Sarah, come on, whatever your input is that Thomas feels like you have to have.
We just had a very, very long MVLS case. It was started in 22. We were the third or fourth attorney on it. I did not
This was a
think,
you problem?
was this me? No.
Oh, it was a Thomas's problem?
No, we got it after, like, the case was ongoing since 2022. We didn't get it that early. We're like the third or fourth attorney.
Oh, okay.
Not
I
the first
didn't-
MBLS attorney either.
I did not think in any world that she would receive alimony because he works multiple jobs and is barely making his own ends meet. But the court found that because she was disabled, that he made 3.5 times more than she did, and that he committed adultery during the marriage, that he had previously been supporting her during the separation, that she was owed alimony. So she now has $600 a month in alimony.
Is she actually receiving it?
Yes, she is.
Wow.
Really?
She's actually receiving her alimony.
Good job.
He also got half of his retirement
And
and her marital share of the equity in the house that he bought after he left her.
sounds
That is
That is a
a
victory.
amazing example of how
Wow.
leveling the playing fields
We
and
leveled up, yeah.
volunteer attorneys who are willing to dedicate a tremendous amount of time and effort
City,
City.
but
make
the
a total difference.
house
So
was in the
thank
county
you
after
for
he's
that,
ended
Sarah.
that house, like, we're done.
What's I've never done that in my career, Thomas. Okay, good job, both of you.
Yeah.
What's the highest amount anybody's like ever gotten like as an alimony award in court?
MBLS or
Like just in general? I'm
just
just,
go with Erica. She's very fancy. She's gonna have.
okay.
I have not done an alimony case in probably longer than some of you been alive.
No, because they all
What-
settle.
Yeah.
Most of them settle.
I think one of my MBLS cases was a very similar one. She had a stroke, her dad was taking care of her, he had to bathe her, had to feed her. The husband did the exact same thing, moved out with a new girlfriend, bought a house like 2 doors down, so she could see him every day. So she got very similar results, but I think it got like $2,000 a month.
Wow.
One of us or me can talk to you afterwards. It really depends on what both sides have. I mean, there's lots of alimony factors. I think the biggest one is the person's need versus the other person's ability to pay. But of course, if they're only married for a year or 3, then.
some of them can be large, but you're talking very, very large incomes,
Right.
like millions of dollars a year. So those cases are few and far between and certainly not MPLS worthy.
Yeah.
So, but they do happen. And I will say your larger alimony cases, it becomes a business decision for them more so than just arguing over it. It used to be easier in my experience to negotiate those before the tax benefits of alimony were repealed in 19, is that right? No.
Yeah.
Yeah, 2019.
Yeah,
1/1/19.
2019, okay. But, you know, for the people that are very, very high income earners, an alimony claim is just, you know, what's my ticket out of here kind of thing, a lot of times, you know, we do have this money, whether I believe they are entitled to it or not, like, sometimes it's just not worth paying attorneys. So I think in those instances, a lot of times you see settlement, so you don't have like these big awards from judges and magistrates in those positions.
But yeah, it's more part of a global settlement, or I would usually negotiate a lump sum or part of the settlement, not call it alimony, call it something else or prepay it,
Yeah,
depending on cash flow.
it really just depends on the case. But I think as you are finding more and more two-income earning households, in my personal practice, I am seeing less and less alimony claims. Occasionally you will see, you know, a rehabilitative alimony claim. For example, mom stayed home for a couple years until the kids got into elementary school so that they weren't paying, you know, exorbitant daycare costs. But that's really just, she had a degree. She took a break from the workforce and just needs some time to find a job kind of concept as opposed to, you know, your really long-term alimony claims anymore. That's my personal experience. All right, marital property. Everybody needs to remember that Maryland is an equitable distribution state. We do not have community property. Equitable does not mean equal. Everybody forgets that. However, I would say my personal experience on the bench is that it is more often than not equal, even though that's not what equitable means, okay? You know, when you're looking at this from a settlement perspective, you know, if you're arguing over 40 or 45% to one spouse and, you know, 55 or 60% to another spouse, you know, obviously in your pro bono cases, they're not paying attorney's fees, but in your paid litigation cases, sometimes you have to have like a cost benefit analysis. It's not worth chasing that 5 or 10% difference in trial because they're going to pay you more in attorney's fees to get there, right? I mean, people don't have a lot of extra money these days to be accruing these very large, you know, assets or, you know, large amounts of marital property in my experience. So there's always that cost benefit analysis. In order to deal with marital property, the court has to do a 3-step analysis. It's laid out in, what is it, 200-ish of the family law article. They have to identify what is marital, what is non-marital, or what is partially marital. So there could be some premarital and some marital portion to it. The value, what everybody needs to remember is the value is as of the date of divorce, not date of separation. If you are negotiating an agreement, you can negotiate whatever valuation date you want. But if you are going to trial, the valuation date is the date of divorce. So you want to bring those numbers as close as humanly possible. The last part of the 3-step analysis is that the court must make an adjustment, a monetary award, transfer, or use or possession of the marital property. I would strongly encourage you to ask as many questions as possible about how an asset was acquired. Did the house get purchased with premarital funds, even though it was purchased during the marriage? Did the house get purchased with gift money from one spouse's parent or inheritance, for example? Those are all certain things that you need to ask and you want to know up front. If your client is claiming any sort of non-marital portion of an asset, all or in part, the burden is on you to prove that it is non-marital or the court will lump it in as a marital asset. You also need to pay attention to things like commingling. The biggest place you see that is retirement accounts. People bring retirement accounts from their current employer into a marriage and then continue contributing. That's a commingled asset, okay? The other big example of that is if somebody receives an inheritance and they deposit it into a joint bank account that has joint marital funds in it, or not joint marital funds, but marital funds in it, sorry. The other one that you need to look at is dissipation. There's a lot of case law on what constitutes dissipation. The gist of it is that one spouse is spending money to prevent the other spouse from receiving it as part of the divorce. Again, just a reminder, the valuation date is the date of divorce, not date of separation. Anybody have any questions about this? Go ahead.
So when you're talking about commingling, if they did commingle it, but you can go back and show that, like, the one spouse had received a gift or an inheritance, then you can say that is non-marital, even though they've commingled?
You may make that argument. However,
Yeah,
the counter to that argument is that you gifted
right.
the non-marital asset to the spouse by depositing into a joint account.
But you think it's worth looking at that issue?
I think the answer is it depends on how much the asset is worth, if you want my honest answer.
Yeah, for
Anybody
how
else
long-
have any other?
Yes, how long
opinions?
did you leave it commingled? Did you like, oh, oops, I made a mistake and immediately transfer it back out within a day or two? Or did you leave it in there for months? Like if you inherited money, your convenience, the convenience just put in your joint account, it's immediate gift. But if you
Yeah.
then transferred it out like a few hours later, the next day, one could argue where you could trace out that's the source of funds.
Right.
Yeah,
But if
It's an
you,
argument.
but if you commingled it and you never did anything about it, it's.
I
kind of-
think you're SOL if you want my honest
That's what I
opinion.
think.
But you probably spent out of the account.
That's
Then
the
question is,
problem.
did you spend the non-marital or the marital?
That's the problem, is how do you figure out which portion you spent, right?
Can't.
You can't, and that's where the problem lies.
I have a question about.
Sure.
So when there's a property and the parties separate, they were both paying the mortgage, the parties separate, and then one spouse is paying that mortgage for like a year or two before they file for divorce. The asset, the value is still gonna be as the date of the divorce and not the separation.
Yes.
Although there's an interesting new case called Sims, but I don't think,
Is it reported?
yeah, I don't think
Huh?
quite frankly, the bench knows enough about it. Leave it at that.
How recent is this case?
The HOCO bench knows about it because they're the ones who told us.
True, there's that.
What did you say? I didn't hear.
The Howard County bench knows about it because they're the ones who told Sarah and Thomas about it. Did you learn the hard way on this one, guys?
No. it was
Oh, okay.
maybe a little-
Oh, I was like, oh, hopefully you didn't learn the
Like
hard.
a bench meeting,
Ah,
I mean, a bar meeting.
Yeah, got it.
But I think Thomas and that, it was a longer separation and it
Yeah.
was new property.
Right, it was property acquired after the separation.
Which is still marital
And
property.
you know how, law is. It's really narrow set of facts. Will probably never come to any of us, much less MPLS cases. Although this dude that we just got, he bought that house after separation, but
So the answer is, it is technically still marital property under the law, but
definitely.
there is, like anything else, there are nuances to it. One of the cases you should read is what, Crawford versus Crawford, which has to do with, can someone claim,
Mortgage paid out.
yeah, mortgage payments for the 50% that they paid on behalf of the other spouse to carry the house, including any like repairs and maintenance costs, those sorts of things, and get reimbursement from, as a monetary award at trial.
Thank you.
That's the big one, right, guys? Am I missing anything else?
Although I don't, Erica, haven't really seen that work either because inevitably the person paying the mortgage also lives there.
Well, correct. Yeah, so
Probably
there's,
makes more money and.
yeah, there's always some nuances too. If they're receiving the benefit of living there as opposed to having to rent somewhere else, right? Why should they get one half of their rent paid and the other spouse not?
June 2025 was the Sims case.
Thank you. Is it Sims v. Sims?
1M.
September term.
1M. Do you mind sharing that with the group, please, Erica, via email, since you have your laptop up? Thanks. All right, anybody have any other questions about this slide? Okay. Oh, I thought you were raising your hand, sorry. All right, so marital property, the very basic definition is property acquired during the marriage by either party regardless of title. So retirement accounts, right? That's individually titled, but can be marital property. Appreciation on non-marital property attributable to marital effort. So think if somebody had a premarital piece of real property and the parties put marital money into it to maintain it as a rental, for example, during the course of the marriage. That's really the most common example in my experience. Property title jointly is presumptively marital, so keep that in mind. Non-marital property by definition is property acquired before the marriage, property acquired by inheritance or third-party gift. Again, we talked about this, what happens when you commingle this non-marital property, that's where it becomes problematic. Non-marital property is also any property excluded by valid agreement or property traceable to any of the above. I did mention this, but just remember, if you are claiming something has a non-marital status, the burden of tracing it and demonstrating it is on you. So I always tell people, if you can convince me and I can convince opposing counsel that it is non-marital, then you have a good chance of convincing the court. I think, you know, for the mentors in the room, we have a pretty good gauge if opposing counsel comes to you and says, this is the premarital value and here's the bank statement from that day. And, you know, every bank statement for the last 20 years and I can show no marital money was put into it, you know, it's going to be a pretty easy sell. And if you're going to sell opposing counsel, you're probably settling on that issue anyway. I will tell you that non-marital property, in my experience, is often one of the big things that holds up settlement agreements because of this, you know, burden shifting to the other side. Anybody have any questions? Okay. The monetary award factors are in 8205. They are very similar, but not identical to the alimony factors. There's a lot of, as it relates to like the age of each party, the duration of the marriage, the circumstances that contribute to the estrangement, the monetary and non-monetary contributions to the family. Those are the big ones. They're also going to look at what sort of alimony award they're going to get, or if they have use and possession of any family use personal property or the family use home. The counter to that is in the alimony factors, they look at whatever monetary award a party is going to receive as well when they're assessing alimony. So these really do work in conjunction with one another in my experience. The lovely catch-all for the alimony and monetary award factors and the custody factors now, right, is anything else the court considers necessary or appropriate. So just put your finger up in the air and feel the temperature of what a judge or a magistrate wants to do on any given day and know they're kind of sticking points, right? All right, anybody have any questions or input from the mentors? Go ahead.
So whatever the court considers necessary or appropriate for what, to do what?
To make a monetary award or to award alimony or, that's a great question. I don't know the answer to your question.
I never thought of that one before, like, yeah, is very appropriate.
Yeah, yeah, necessary or appropriate to what? Who knows? $1 million question. Whatever the judge or the magistrate deems relevant. Very open-ended.
I was gonna say, keeping with, I assume you're gonna talk about counsel fees in a minute.
Yeah.
That while you're already comparing the 8-205 versus 11106, marital property versus alimony factors, the factors going into attorney's fees is also very similar. So if you think of all the, the marital award, alimony, or attorney's fees, think of like three parts of the same pie. If you get one, you get less of the other. At least that's what I always explain to clients when they're looking for counsel fees. Essentially it's the same pot of money. It's just how much goes allocated towards fees, alimony, or a marital award.
Yeah, you're not wrong.
I just want to throw one factor in here, because when you went down to any other factors the court considers necessary or appropriate. And you mentioned your longstanding case. I really think it depends on how we as attorneys finesse the case in front of the judge. And I'm going back to Jennifer's initial presentation. And you have to be really in tune to how your client is going to present to the court, how the other party is going to present to the court, and what the judge is going to perceive. Because I had a monetary award issue where I had a person, my client proved without a doubt that the property that they lived in was his. He had all the factors to going there. We had a number of hearings before the judge, and the opposing party was a pro se litigant, and they get to the final day of the court, and does a terrible job of trying to bring back a protective order against him, and the judge was very angry with her. So she shows up at the hearing. She wanted her son to testify, and we all objected, and the judge agreed. And then the judge says, well, we're gonna set a date for your protective order. And she goes, oh, that's my birthday. I can't make it. She goes, well, let's try this date. She goes, oh, no, I can't make that date either. The judge goes, no problem. I'll make the decision. She ordered my client custody of his daughter, of her daughter, their daughter, and the house, and she calculated child support, and it was to zero. My client walked away. It all came down to how the other party, the pro se litigant, fell in the eyes of the judge, and that whole entire presentation that Jennifer gave is so relevant to everything we do. You have to figure out how to finesse the court, and you may get what you want. You may not, if your client goes the other way.
Yeah, I mean, we've all had conversations with our clients about, we need to settle this because you're not going to appear the way that you want to appear, regardless of what the case is or is not. And I mean, I hate to say it, but you're absolutely not wrong. How the court perceives you, regardless of what your story is and what evidence you have to support your position, sometimes is the thing that rules the day. All right, how long do you want to take for a break, Jen?
What do you think?
What time is it?
It
May I ask
is
that question?
1:15.
In one business day. She is wonderful. I have asked her even in my paid cases where one spouse does not earn a ton of money to do this, or in a family that I really believe needs it. And the cost is the pushback. It's such a nominal fee anyway, but sometimes that's just the thing that people hold on to before they will use it. And I have asked for waivers in those cases. I have worked with my families and utilized some of the other apps candidly. This one is by far the best. They are also in the process of working on a partnership with SoberLink. Does everybody know what SoberLink is?
Oh, wow, that's gonna be something.
That's great.
Sorry, they also, for anybody who uses Clio as their software management, you can get a free attorney account and they will upload all the communications into Clio if you link your Clio software to it as an attorney.
To OFW, not.
Yes, to OFW, but it will backdoor through SoberLink when SoberLink works. So SoberLink, for anybody who has alcohol use problems in their custody cases, SoberLink is a blow and go device that links to a parent's phone. Sorry, why are you laughing at me?
I mean, blow and go is funny. Look at this. It's like you're marketing for them.
I have a little brother I didn't want.
I mean,
And the benefit is there's no wait, it's tamper proof. There isn't a cost to it. It is fairly expensive upfront, but sometimes it is well worth the money to provide peace of mind. And the reports can be sent to the other parent, the non-alcohol using parent. You can have it set to the custody schedule so that, I write in orders, X, Y, and Z parent will use it 15 minutes before the pickup time, and once before bedtime, and once next morning at a certain time, and that the other parent can request randomly once per month, for example, and that it will go on for so many times. And what happens if there is a positive alcohol screening on the SoberLink device, including makeup time or resumption of access and all of those sorts of things. So it is a very wonderful device. They are in the process, like I said, of partnering with OFW. I am not paid by OFW. Let's be very clear about that. In addition to MBLS not having any funds. I'm not paid. I just genuinely believe that the app is good, and they have really come a long way since I first started using them many years ago.
I don't say I'm in the middle of a trial from hell now, but where my client's using the SoberLink device, it's probably about $400 for the device, plus about $250 a month for the monitoring. Every time you
A month or a year?
A month.
The
It's
monitors?
expensive.
Oh, I didn't remember the
Yeah, so
monitors.
he's
being on.
doing a twice a day. So basically, the idea is when he would have the children.
with unlimited blow and goes.
Yeah,
You
right.
just needed to say it again, didn't you?
Well, I wanted to point out the unlimited part.
Yeah, but the point is, he also, every time you blow, it takes a picture. So that way you can't, and then when you want to go to court for $50, they will send you a certification for like business records to send you a certification of all the testing. So while you would it sends out an email to say, your attorney, opposing counsel, and all the parties within seconds of blowing. Or they'll either give you a missed, whether it was a missed test, a positive test, or it was a satisfactory test. But the idea is it takes a picture, so that way you can verify it was actually that person blowing it each time for the test. And it's very helpful, obviously, when you're trying to disprove that your client's an alcoholic or has alcohol issues.
They are also very cooperative with subpoenas to show chain of command for the evidence, which is also very nice too.
Yeah, like I said, it's they charge $50 and they usually would get you the records within 2 or 3 days.
Yeah.
Of asking for them, unless you have opposing counsel who's just being difficult. When you get them 3 days before trial and they argue that it was less than 10 days, even though counsel gets the same emails you do, showing that that the person's been in compliance the whole time.
Like they wouldn't, yeah, I mean, they get the same emails. You also have the ability to like download the whole calendar.
Correct.
And
But
they still give you a hard time.
Yeah, but they give me a hard time because, it was not within 10 days of trial and you're violating the discovery rules, the rules of discovery, even
Because
though.
it's not beneficial to their case. We
Right.
don't know why they're being difficult.
I just want to add, in furtherance of our disclaimer that we don't have a relationship between MBLS and our Family Wizard, we are actually hosting a virtual training with our Family Wizard on July 15th, where they're going to do, and really, thank you, Jessica, because there are others and you certainly can explore them, but I tend to think, why reinvent the wheel if somebody who's doing this all the time, every day, has a very high recommendation for a product, then I'm going to take it. And the fact that they will do waivers. And so July 15th, virtually, you'll see it'll be posted, but they're going to train the tech tips, because another thing they do, which is pretty extraordinary, is instead of the thousands of screenshots you get, but communications from your clients when they're texting back and forth, you do our Family Wizard. It keeps track of the entire conversation, and there's a way to download the entire conversation so you're not getting snippets. So that's also, from a time perspective, doing MVLS cases, a major bonus. And highlighting one more wonderful training is on September 15th.
Oh, am I doing this one?
Yes. Our wonderful Jessica Zajura is doing a tech tips for family lawyers training for us as well in September. So you'll see that coming down the pike as well, but I highly recommend both of those. All right.
Can I just add one more
Quick
tip
question.
for OFW? I'm so sorry. The best part that I use it for is it's a communication. It's an email platform for parties, and it will say the time down to the second it was sent. And it also indicates the time that it was read. So when you do not have communicative other parties, they don't read an email for 6 weeks. It really helps on joint legal custody or legal custody arguments in court, that they're non-responsive, and it's.
I did hear you, Michelle. I'll piggyback off of what Erica just said as well. You can have an attorney access to your client's case so that you don't have to wait for them to download everything for you, which is also nice. Or for those of us who serve as BIAs, privileged attorneys, those sorts of things, you can also get access that way. And as the children get older, they can actually get access to certain features like the calendar, for example, to know where they're supposed to be, what activities, those sorts of things, but you can block them out of parent communication and so forth. So you don't see that component, in my experience, used as much, but it does. I have for some older teenagers, and it allows them to communicate with the parents too.
Quick question.
Yeah.
Our Family Wizard waiver, is it just for the 1 year or is it continuous? Is it year after year?
I think you have to, my recollection is you have to renew it year after year.
Renew, but you can get more than 1 year waiver.
As far as I know, I've never had anybody be denied. Don't quote me on that. Ask, email Nicole. I'm going to volunteer Nicole. She's not here, so I'm going to volunteer her. Email her and double check your question, Michelle, but I believe the answer is there's no limit.
That is great.
They do, my recollection is that the application says that they have to have like an attorney sign off on it. So like I have to certify that like this client came to me from MVLS, for example.
Well, because they're working with you guys, that's the best way to go. I will honestly recommend that, because
if you work in the larger firms, they will actually come to your office and do trainings. Occasionally I randomly get like handouts to give my clients about like pamphlets and stuff in my email. I have SoberLink ones too, if people want those.
Emails from OFW
Yeah.
and SoberLink, they want to
And
come do a
July
lunch and learn.
15th Is a lunch and learn, and you'll get a free gift certificate for $20 for your local restaurant if you sign up for training.
Oh,
But it has to be 48 hours before the actual training, and
is
the,
that one in person?
no, virtual.
Oh,
And the person whose card you have is actually a social worker, and I spoke to her at the Family Law University, and she was very committed to helping any client who needs a waiver for the services get it. So I would reach out to her.
I mean, I don't know if anybody there is no better way than our Family Wizard. There are some other programs out there too, but I can't think of a better way to get people to communicate, because one of my opposing party goes, I don't want to pay for that. Can't we just use the phone? And my client goes, I need to be protected from this individual. The only way to protect myself is through a platform like this. And he says, I really need the fact that I can track all of my communications. Other than that,
sometimes you offer to pay for it for the other party.
other than that, it wouldn't happen.
Back to child support. I have finagled a downward deviation for our Family Wizard.
Did you see it?
What?
Yes, so just in case anybody needs to know, I have in fact requested a downward deviation for child support when a parent has paid for both parties' accounts.
Pretty cool.
It's probably judge and magistrate specific, but I have negotiated before. That's what I got for you.
Even though it's $100 a year?
It was like a very de minimis child support amount, and so I
You
just
talk
justified.
fast, so it would be still worth it to your client.
Yeah. I think I wrote it in something, actually, Thomas. And the judge just signed off on it.
Sorry.
Annoying little brother,
I'm
remember?
sorry.
I know he's doing it because I said it. All right, let's talk about attorney's fees in family law very quickly. These are the various different statutes. There's one for divorce, annulment, alimony. There's one for marital property and monetary awards. There is one for alimony. There is a separate one for child support, custody, and visitation, and one for court-appointed counsel for a minor child. In addition to all of those, there is also 1-341, which you don't see very often, for bad faith or lack of substantial justification. I don't know about all the other mentors, but it is not uncommon, or the most common use of 1-341 I've seen is when there is a really litigious attorney on the other side. So those are just the various different statutes. I would implore you to read them. They are almost all identical, but some of them do have very little nuances. The gist of what the court must find when making an assessment on attorney's fees and family law is the financial status of each party, the needs of each party, and the substantial justification for bringing, maintaining, or defending the proceeding. We follow here in Maryland the American rule that each party should pay their own attorney's fees. The fee shifting is a statutory exception in family law. That is, I think, fairly, in my experience, unique to family law, but doesn't happen as often as people want it to. Just a reminder, if you don't ask for something in your initial complaint or motion, that you are not entitled to it. So even if you think your client is not entitled, sometimes you want to throw in the attorney's fees just as a protection, because you never know what's going to happen throughout the duration of the case.
Can I just ask there, are you saying that in filing an initial complaint, it would be worth mentioning attorney's fees?
I always ask for it. My request for a relief, because I have no idea what's going to happen in those 9, 12 months, 15 months before I get my divorce or custody trial.
But if the court finds there's a lack of substantial justification,
No,
doesn't have to consider the financial
Yes,
needs and all that stuff.
It does. I believe it's an and, if my memory serves me correctly.
12103C, my firm had a reported opinion about it,
really?
defining good cause.
That's a
because
lower standard.
The court conflated 103B and C. And so when Annapolis,
I was gonna say, I thought the statute was and. No.
Right, 12103C is different.
yeah,
And I was cut, and no magistrate has fought that argument for me for years.
yeah, no, they,
I'd
so
love to read that.
they.
Yeah, was it
they-
recent?
Yeah, within the last year. I think the last time we were here, we were discussing it and the client got, I don't know, 600 $1,000.
It's a Montgomery County case.
I was gonna say that
Makes sense.
surely is.
I was gonna say, that's, yeah.
Yeah.
That's not the rest of the world's money. That's Montgomery County money.
Absolutely, just.
I mean, but
Will you circulate that case?
Yeah.
Just so everybody has it? Thank you. There is a reasonableness factor. You need to submit what is the rule? Anything over $500 is my recollection. You have to submit an affidavit, right? Isn't that what the statute? Yeah, you're supposed to submit an
Mhm.
affidavit. Am I wrong?
No, you're correct.
Okay, sorry.
Is that one?
That's why I always ask for
Well, so they
$4.95.
have the right to reject the claim for attorney's fees over $500 if you don't submit an itemized fee affidavit. I have very weird opinions about the fee affidavit because we have to sign it as records custodians for the attorney's fees bills that we are submitting to the court. But I think personally that we're making ourselves a witness in a case. But the rest of the bar does not seem to agree with me on this opinion, so we just keep on trucking along here, guys. But yes, there is an itemized fee affidavit that you have to submit along with the attorney's fees bills that support it. You can file it in advance. If you file a motion to compel and ask for attorney's fees, it needs to be an exhibit if the attorney's fees are over $500. In the materials, I believe, is my affidavit, so you're welcome, all of you. I have attached it over the years and modified it as I have dealt with various different challenges from other attorneys and those sorts of things. Even in our MBLS cases, we want to be requesting attorney's fees. What that means to all of us is you still need to be keeping track of your time. Your 0.1, your $135 filing fee, even if it is waived, you need to keep record of it, those sorts of things. Okay? There is a case that is ancient at this point in time, Henriquez. It is up there. It permits fees when the prevailing party received pro bono representation. It is a 2010 case. Has anybody here, any of the mentors been successful under this? There you go. I knew you would know what it was when I asked you yesterday, Thomas, and I couldn't remember. The word incurred does not appear in the statute. That is the underlying premise of this case. That means that the party does not have to pay it. You need to submit your itemized affidavit at your normal rate, not a reduced rate, at your normal rate.
Oh,
Yeah, sorry. Reduced rate.
that's why I was successful.
The award goes to the organization, so the award comes to MBLS, not the attorney.
Oh.
Your agreement is to do the work pro bono.
For the client, maybe?
No, my understanding is it is directly to MBLS
Okay.
and it
In one
funds
case, I think.
future.
There was an award and it went to the client. There was actually a house, and this case is, never gonna end. But eventually the house got sold, and anyway.
It is intended to level the playing
Yeah.
field. That is the purpose of this case.
Way over 30 hours. Sometimes you guys are generous.
Oh, for the acute care cases?
That the party who's ordered to pay attorney's fees is just gonna write you a check or write MBLS a check.
Yeah.
Right then and there.
The other thing everybody
Or pay
needs to
down.
know is that this is just a random piece of Jessica knowledge. If attorney's fees are awarded in a custody case, they cannot be written, or alimony, they cannot be written off in bankruptcy because they are the nature of support.
You probably want to write the proposed order and put that phrase in.
I'm just telling everybody now because you've become a creditor of the bankruptcy estate. There is a great American Bar Association book out there about bankruptcy for family law attorneys.
Oh.
In all your spare time, I really encourage you to read it. It is one of my favorite books, and I like to cite this like bankruptcy statute because people don't realize it.
So Jessica, I thought that was only for child's counsel. So
Nope.
you're saying that if
Yeah, there's
you
case
are
law.
awarded, if I represent mom, you represent dads, I'm awarded, you're awarded fees.
But it can't come to the attorney. That's the caveat. So you can't have it reduced to a judgment in favor of the attorney because it's no longer the nature of support.
Lesson number 2 I learned today. This is,
You're welcome.
I'm now a mentee.
There you go.
Wow.
It's all about your life experience, right? Like
Yes,
that's
I
really what
do.
practicing law is. Yes,
Who wrote that?
Thomas. That's why I'm telling you, pull the book.
Thank you.
I can see if I can find it, but ABA, the book is very helpful and it actually has the language in it, Thomas, that you're referring to.
What is the book called?
It's like Bankruptcy for Family Law Attorneys by the American Bar. It's through the American Bar Association. It's like a grayish blue book. I can see it. It's sitting on my shelf. It's very well loved. All right, so the 9207 joint statement of marital property, there is a Maryland judiciary form for this. Is required in divorce, annulment, and property disposition cases, must be filed 10 days before the merits hearing. It also needs to be filed before the pretrial or settlement conference usually. So check your scheduling order. You need to update it. Yep, that's it. It's green, sorry, not blue. Yeah, the Family Lawyer's Guide to Bankruptcy, Forms, Tips, and Strategies. You can buy it on Amazon. I really implore you to wait until ABA does their big annual sale and you get like 20% off once a year. So, the 9207 property statement, I always file one at the time of the settlement or pretrial conference so that the settlement officer has access to it for negotiation purposes and then amend or update it prior to trial. It includes the description of the property, the title, the fair market value, any liens or encumbrances, and the net value, whether it's marital, non-marital, or partially marital, and the source of the non-marital claim so that everybody knows what they're talking about. It's a great summary for your judge in trial, and allows him or her to follow along a little bit better when you're putting on any testimony about various different items of marital property. Make sure you include all real property, bank investment, retirement accounts, other types of deferred comp, stock options, vehicles. People often forget the cash value of life insurance policies, any crypto and digital assets. You can also include frequent flyer miles and rewards points, business interests, your high asset personal property. Some people want to put every article of clothing, every picture, every piece of furniture on there. I wouldn't recommend it, but sometimes you have to do what you have to do to get the other side to agree. You can also put marital debt in there. When the parties disagree, make sure you file a single document so that the court knows what each party's position is. Sometimes opposing counsel or the opposing party will not cooperate, and then you have to file it with just your client's position. When I have had to do that, when I come to trial, I always make sure I bring whatever written communications I've had so that they know I did try to make reasonable efforts. It's a good way to protect yourself for attorney's fees on that issue. Anybody have anything to add about that or questions? Okay. 9204.2 is the joint statement concerning custody and access. It is required in all custody and visitation actions. The timing is required by your local DCM and is usually directed by your scheduling order. Most of the scheduling orders I'm seeing have the filing deadline to be simultaneous with the 9207 statement, if there is one in a divorce case, so that it's prepared in advance of the settlement conference. It can be updated prior to trial if you need to. I will be really honest, I first hated this tool and I've learned to love it, because I put my client's entire request for relief and all the specifics in this document. It ends up looking like the terms of a parenting plan when I am done with it, because then when I get to trial, I just ask the court to take judicial notice of the one that I filed. And I usually hand the judge or the magistrate a copy and say, this is what my client is asking for a whole multitude of reasons.
Do you use the court form or do you have your own template?
Oh, I use a Word document, ma'am.
Okay.
I type. If you can't tell, I talk a lot and I type just as much. I have a Word version of the 9207 statement too, if anybody wants either one of them. The court forms are great, but they do have their limitations, as I'm sure everyone is aware. I feel the same way about the court marital settlement agreement and the court parenting plan. They're great for simple cases, but
Pro se litigants.
yeah, that's better than nothing. Absolutely.
Can I have a question for you?
Sure.
On this joint statement, if the other party refuses to sign, I
do the same thing I do for my property statement. I file it. Yep.
Thank
And
you.
then I ask for attorney's fees at trial.
Doesn't it
I'm
allow,
gonna put that little note.
doesn't the form allow you to express this is solely one party or the other?
That's why I use my Word document and then I change it to plaintiff or defendant's statement. But I leave their,
And I'm talking about the parenting plan.
yeah, I have a Word version of the
There was a form though that
9/204.2.
said that the parties like could not agree and.
Yeah.
Yeah,
Wow.
on the
Like,
court form, there's
yeah.
like a checkbox.
Yeah.
When I file it as my Word document, I just change the title of it.
Mhm.
It's usually a signal to the court. I'd like to hope that my reputation is such that if they see that I am filing this without the other party's input, it's not because I didn't try. But I always bring the communications to trial. That way, if a judge or a magistrate asks me, I have the documentation to demonstrate from that perspective, because again, I think it demonstrates the parties' abilities to co-parent, to communicate with one another. I break mine down all the way into what time I want the exchanges, where I want the exchanges to happen, the specific holiday schedule. Because here's the thing, if you don't give the judge that or the magistrate that information at trial in your closing, you're gonna get whatever random thing he or she comes up with, and rest assured, it's not gonna be what the parties want. I have learned over the years, and the mentors can certainly speak their piece about this, but the more heavy lifting I do on a custody and property case for a judge or a magistrate, the more successful my client tends to be. Not from just an evidentiary perspective, but from a he or she got what they asked for. Because you're creating less work for their law clerk. These are kind of tips. I think I dealt with most of these. Make sure you talk about what happens if you have kids that are not school age and what happens if the schedule needs to change when they are school age. I always make sure I delineate that, for example, or, what sort of resolution you're gonna have, like ADR resolution, mediation or whatnot, if they're gonna do that as well, if that's what your client is proposing. The last statement that needs to be filed in advance of trial is the 2-504.2 joint pretrial statement. Not every jurisdiction requires these. But I am seeing in my practice that more and more are asking for them in places that they didn't. Anne Arundel County has started asking for them. Howard County, I think, has always had it on their scheduling order, but they didn't really use to enforce it. They are starting to enforce it more now. So check your local DCM and scheduling order to talk about deadlines. This sets the contested and uncontested issues, what witnesses are being called, the exhibits that are being entered into evidence, and the request for relief. There are certain things, if you look at the rule as to what needs to be included, and how long sometimes you need for a case, and what sort of, where the settlement posture is of the case. Again, if I can't get the other party's input, I will submit it as just my clients and then keep the documentation from the communications to demonstrate that I did try to comply with the rule. That's the big one. Trial stipulations. I think this is an underutilized tool for people. This is agreeing with the other party or opposing counsel ahead of time about certain facts, certain documents that might be needed to be entered into evidence, those sorts of things. I know in talking to some of the mentors, we are all running into more and more time limitations and those being more strictly enforced in many jurisdictions. Trial stipulations are a great way to get ahead of that. If you can agree to certain facts that are not in dispute or the entry of certain documents. So for example, if the parties are fighting over custody, but there's no dispute about what either party's incomes are, what the expenses that belong in the child support calculations for the minor children are, those sorts of things, you can stipulate that these exhibits are going into evidence, or that you can stipulate that this is mom's income, this is dad's income, this is who pays the health insurance for the children and how much it costs, those sorts of things. That way you aren't cutting out a lot of your trial testimony on that issue. And it can very much streamline your case. I personally think stipulations are underutilized. Sometimes I don't know what they are until, a week before trial. But if you walk into trial with opposing counsel or the opposing party and you have this document and you just read it on the record and both parties say, this is what we're stipulating to, the court will accept it as that.
If you're in Frederick and you have a PL in front of a magistrate there, you have to have stipulations. If you don't have stipulations going in, they will send you out into the hall.
What? How can they force me to agree on? Okay, never mind.
Because it's the the easy stuff, like the names and ages of the children, anything that can speed it up, because Frederick is also very, very far behind right now.
Well, you're correct. They've been
You're
very
getting
far behind.
like 2 to 2.5.
You're not wrong.
Potentially, so.
Now I understand. Okay.
2 to 2.5 years?
Yeah, in Frederick. That's normal. That's normal for
The
them.
merits, yeah.
Yeah, when the kids are say 15 and 14 and the trial's 2 years out and it's like, what's the point of a
I
modification?
mean, it's like trying to file for divorce in Montgomery County.
You're gonna have child support in arrears for that many years?
They did
No
redo
way.
their case management thing, and it started in January, and things are speeding up. But there are cases out there right now that started in 24 that have not had their merits hearing yet in Frederick.
Yes. And if you don't have children, you're the bottom of the barrel is what I understand,
Yes, and
which is the same everywhere, but it's really bad. Anyways, trial stipulations are great. You can often look to that joint pretrial statement to, kind of start the basis of your stipulations. If you're really prepared, which means you're better than me, you can sometimes even file these before your trial date, but good luck. But I do think they are underutilized in my experience. And again, when you are on the game clock for a PL hearing or a magistrate's hearing, or the court says you have 1 day and you really only have 6 hours of trial time, this is a great way to speed that along. And it's a lot less room for your client to make error in their testimony. Okay. So think about how your client appears to the court and where you might want to stipulate, okay? Just remember though, once you stipulate to something, you can't unstipulate it. There's no changing your mind, so you gotta be sure about it, okay? Opening and closing statements, your opening as a roadmap, it is not argument, it is to tell the court what you anticipate the evidence being. It frames your case theory. It's not uncommon in my experience, again, when we get to these these situations with the judges and magistrates where there are very short time limitations that sometimes you want to cut out your opening. That's really strategy. Again, I had a 2-hour PL hearing in Anne Arundel County recently, and I was like, I talk fast, but I don't talk that fast, and therefore I'm not spending my 3 minutes having that conversation, because the last thing you want is your client or the opposing party to be on the stand and be cut off in the middle of their testimony. Closing is where the argument is permitted and expected. It ties the evidence that was presented, including any changes of evidence that you didn't anticipate when you gave your opening statement, to the legal standards. It walks the court through the statutory factors for custody, alimony, child support, marital property division, attorney's fees. Again, this is where you tie it all up in a pretty little bow and you ask for specific relief. Again, use those joint statements to the best of your advantage during these, especially if they're already in the court file, which they should be. You also can get out ahead of, argument regarding any weaknesses in your client's case. I am finding in my personal experience that judges and magistrates are asking more and more questions a la appellate judges in closing. I hear you over here. You agree with me?
Yes.
I'm seeing that more and more in closing in circuit court. I welcome it candidly because it gives me some insight as to what a judge or a magistrate is thinking. And, part of our job is thinking on our feet. And so sometimes I can, tailor the rest of my closing to whatever the question was. This is just, a little bit more on the opening statement. And the closing statement. Cross-examination and direct examination. Just remember, when you think direct examination, your client is telling the story. The witness does most of the talking. You're doing a lot of open-ended questions. I always tell my client, you'll see me sitting back in my chair and reclining and just, almost doodling, because they are doing so much of the heavy lifting, as opposed to when opposing party is on the stand or another witness that's not being called on direct. I will sit much more upright. I will be taking a lot more notes. You can just see the change in demeanor for me as an attorney. The goal on direct examination is often to develop favorable testimony. It's much slower in pace. Again, if your client is the one on the stand, you want to get out ahead of any of those, kind of bad facts, for lack of a better way to describe it. Cross-examination is when you are asking questions of the other party's witness. you control the line of questioning, you do most of the talking. That's where leading questions are, very expected. You're going to suggest the answer to the question in your question itself. You often use this to extract concessions, impeach, limit damage, those sorts of things. Much faster. I almost try to think of it as like it's a request for admission, but it's verbal. It's a great way to think about it. It's one fact per question to kind of build on what you're trying to demonstrate, right? These are just some examples of direct examination. I assume since we've all gotten here, we know this, but if you have any questions or need any help, just let me know. I always add things at the end of my cross-examination questions like correct or isn't it true? There's a lot of that. Make sure you never ask on cross-examination something you don't know the answer to. You have to know when to stop when you are asking cross-examination questions. Leading and non-leading questions, I think this is where a lot of attorneys really struggle in trial, in my experience. One of my criticisms of family law attorneys is we get a little lazy on these things. You need to know when you can lead your own client. Things, establish facts. The children are 16, you guys got married on X, Y, and Z date. Things that should have been stipulated to that maybe weren't before trial. It's okay. You can get away with leading your own client on those, but the majority of their testimony should not suggest, when you are calling your own client, obviously should not suggest the answer within the question. I understand that this is the counter to what I was saying before, right? Like we are all under the watchful eye of the clock. We are often, constrained by time limits, but that doesn't, prevent us from having to use non-leading questions. The thing you need to think about when you are, kind of confusing the two or using the two is what kind of record do I need if I'm going to have to take this case up on appeal or somebody else is going to have to take it up on appeal. If you call the opposing party, this is one of my favorite rules, guys. If you call the opposing party, they are a hostile witness. You may lead them from the start. There is a rule about this. The judges and the magistrates forget about it. You have to educate them on this. This can win your case. A lot of people are very hesitant to call the opposing party because they think they have to ask open-ended questions and you do not. The same thing if you are calling the girlfriend of the opposing party, for example. They too are a hostile witness. Do not be scared to call them. The counter to that is don't prove the other side's case for them. Be very calculated in the questions you are asking, okay? Again, if you are calling the opposing party, think of it as a request for admission, but on the stand before a judge. Anybody have anything to add to any of this?
So can you, let's say somebody, I don't know, I'm coming from criminal defense, but like, let's say somebody, I've only had this happen during a criminal defense trial, jury trial, and like the state declared their witness as like a hostile witness. And so can you like recall in family law cases, like hostile witness?
Meaning if you are their attorney?
Yes. Well, if let's say other side has a hostile witness, can you recall that person?
Yeah, you
Okay.
can call. So let's use mom and dad because I think it's easier for the example. So if I represent mom and you represent dad, and I call dad as a hostile witness in mom's case in chief,
Okay.
are you asking if you as dad's attorney can call dad as a witness in your case in chief? I just want to make sure I understand all the players, so I answer your question correctly.
Yeah, well, let's say hypothetically, let's say grandmother is testifying on behalf of mom, you're representing dad, okay? And grandmother ends up being a hostile witness to mom.
Because it's dad's mother.
Well, let's just say even hypothetically, it wasn't like, it doesn't really matter the relation. Let's say she ends up being like really hostile So mom unexpectedly can you as dad recall that witness?
I think dad could recall that witness as in his case in chief, provided that witness is on the witness list.
Okay,
Did I answer that correctly? Okay.
but let's say you go into trial, you don't
Well, it depends
expect.
on if it's for impeachment
Yeah,
purposes,
for
that's a
impeachment
different,
purposes,
that's a different,
it doesn't have
correct.
to be.
Yeah, let's say like hypothetically, sorry if I'm like going.
No, but sometimes naming who the parties are.
yeah. Let's say,
Yeah.
like during my jury trial, like I did not expect that witness to be hostile at all, like a state witness.
Yeah.
And so let's say you didn't call that person as like a case in chief. And then that person, and so your dad, and you're like, oh, I did not expect this person to be hostile. Can I, on my direct?
Yeah, I don't think they can limit you on your direct as to who you can call. If
Okay.
they were called the other party's case in chief.
Okay.
Yeah, I don't think that changes. Mm-mm.
I agree.
Yeah. You're subject to the mercy of whoever is on the
Okay.
bench, though. I will be very candid. I mean,
Okay.
I have presented this hostile witness rule to judges and magistrates before, and they've just straight up told me I'm wrong. Well, I hear you, Your Honor. We can agree to disagree. I'm gonna preserve for the record, but at the end of the day, they get to run the room, right? So, I mean, I think you are somewhat at their mercy.
And you also have to, when the person gets off the bench, you have to make sure that they're not excused, because otherwise how are you gonna get them back? They may just be like,
Yeah.
yeah.
That's probably.
Yeah,
Yeah.
you do have to be careful about the terminology that's used, because if you ask for a rule on witnesses, they testify in one party's case in chief, and then they sit down in the courtroom, I think you're precluded from calling them.
Okay.
The other thing is, don't you need to clarify to the judge that you intend to call that person?
Yeah, you can reserve on the right to call them in your
That
case in
way,
chief.
yeah, that way you don't lose he's still under oath.
Yes,
And he can
correct,
come back.
correct. But it also signals that they need to go outside the courtroom, provided you ask for the rule on witnesses. Okay. Did that answer your question?
Yes.
Sometimes though, like I've seen judges say, oh, well, they're here now, let's, counsel stand
Yeah,
up. Are they do that like with, with the parties, right? Like.
It's not proper.
I
It is not
agree.
proper at all from an appellate posture.
Correct.
It makes the record very, very difficult. And this is back to my comment about, I think sometimes family law attorneys,
How do you politely?
I will literally look at opposing counsel and the judge and say, Your Honor, I'm not very comfortable with this in order to preserve the record.
When it
I think it needs to be clear. And it's not because I'm threatening to file an appeal
Yeah.
or anything. At the end of the day, my law license is on the line, and I have to do what is best for the client or for the party that I am representing. And having a clean record is very important, because you can lose. It gets very muddy when that happens as to who's questioning the
Yeah.
witness, what I'm objecting to, what I'm not objecting to, all of those sorts of things. And usually if you phrase it that way, in my experience, a judge or magistrate will be very mindful of what you're saying. And that's kind of like, it's just like objecting as a family law attorney. I think we're a little lazy in that capacity too. And we don't object as much as we should. And the judges and the magistrates don't like it, but it is very, very important. So you have to politely.
I think whenever you say, Your Honor, I completely understand, but I need to preserve this for the record in case this case goes upon appeal. Like that's kind of the little like ringing of the bell, like you need to do this
Yeah.
the way, and it doesn't sound controversial to the
Yeah.
judge. I agree.
Yeah, and I mean, sometimes I'll have those conversations, if you have a colleague as opposing counsel that you are collegial with, I've had conversations about that up front, like, can I just call this witness out of order? Well, normally I would say yes, but, and we're all respectful of that at the end of the day, right? So I do think you need to be a little bit mindful about that component. Sometimes it's not a big deal. Sometimes it's a huge deal. And those, there's no in between, unfortunately, right? So.
Yeah, I mean, I haven't seen it be like a huge deal yet, but like I've just.
All it takes is one.
Yeah, but yeah.
Just to give you a time check, it's 11:45.
I'm almost done. I
Okay,
think.
perfect.
Introducing,
rushing you.
no, you're fine. I'm almost done. Does anybody else have any questions about that or comments?
No, but I think talking about the rule is important. Rule.
Oh.
I think that's important.
Oh, the rule on witnesses?
Mhm.
Do you remember what the rule number is?
Gosh, no.
Okay. Mental exercise there. Okay, so does everybody know what the rule on witnesses is? well, it's really sequestration, right?
Yes, yeah.
It just means that any witnesses have to sit outside the courtroom so that their testimony cannot be swayed. The other component of that is that while they are on the stand, so for example, if they finish at 4:30 and trial continues the next day, thank you, Rule 5-615 is the rule, that they cannot go home and have conversations about their testimony overnight. And normally the judges and magistrates, in my experience, if there is carryover to another day of trial, will give instructions to the witness that's on the stand. Here is the really hard part. You're probably experiencing this right now in that case we were talking about in the hallway.
Mhm.
If you have a multi-day trial that carries over and your client is on the stand and you go beyond the time limit set and you need another day in front of that judge or magistrate months down the road, there could be a position, if your client is the person on the stand, that you cannot have conversations with your client.
I found it to be that you may, as long as you're not talking about what was said,
Correct.
but I think that's a little.
It's a little slippery, and unfortunately, I think it puts us as attorneys in a rough position, because what if something happens? And think about a custody case, what if you represent dad's on the stand, you don't have another trial date for 30 days, and mom starts withholding the child. I can't have a conversation. Can I have a conversation? Probably, because it's a new instance that occurred and it's not directly about their testimony. But of course, our natural inclination as attorneys is to start adding in additional testimony, but it's a slippery slope. You have to be very, very careful about it. And so you have to.
Sometimes you'll have a family member who will remain in the courtroom and he or she's not going to testify. And then they go out and tell all the witnesses what's going on. I've had the other sides, all of his witnesses excluded after I saw that happening in the hallway, took a picture, got two people to witness it, put them on the stand, explain what was Judge Tucker not happening. Was that in our case? No.
I know what case you're talking about now.
Yeah.
And sometimes what I've done is, if I think grandma who's sitting in the courtroom who isn't planning on testifying is going to do that, like you can just know those cases. I say, oh, Your Honor, I might call grandma. And so I do that routinely. So sorry if
grandma gets upset with you.
Grandma does not like that.
It's not my job to be liked.
My job.
It's not my job to be liked. The best cases are when the opposing party hates your guts because you did your job well.
Making faces and chewing her son or daughter anyway.
Yeah. Oh, yeah. You'll hear them muttering under their breath as they leave the courtroom. I mean, I've gone so far as to ask, like, when another attorney has a paralegal or a legal law clerk or somebody sitting in the courtroom that I just genuinely have no idea who they are. I'm like, Your Honor, I don't know who this is. Can you at least tell me who this person is for that very same reason? Right. So, just things to think about.
Yeah, we just asked the judge basically made a special ruling or explanation at the end of the day about what we can or cannot talk about.
Oh, with your client?
Yes. So anything proactive, like if it was denied access or they had to go to the emergency room, or when something happened, we could talk about it as proactive, but not anything that was already said or in the past.
Which is such a slippery slope as an attorney. Like, it just puts you in such a bad position and your client in a bad position, right?
The one exclusion, I'm just telling you this because I learned this in my trial, and I should have thought about it, but if you have an expert witness who needs to listen to testimony, they are allowed to sit in during the testimony so that they can comment on it. And
Correct.
It's just one of those things that I hadn't really known was a specific exclusion. So
yes, you're correct.
And I got pushback on that just last week or the week before. I'm a new magistrate and I had to gently remind Her Honor that experts can rely on hearsay, and if the opposing party was going to be testifying about his ability to work, then my expert needs to hear it because that's what it was about. But if not, if the opposing party is not going to testify about that, then I guess the case is over because he's going to not be able to prove that he doesn't make any money. So
what's the cost for a vocational expert?
Usually it's because somebody is.
The cost or the cost?
Oh, thank you.
Yeah, the cost.
There's not a lot of difference in between the experts. So usually it's about $3,000 initially to do the report, and then about 1,000 or more. So it's like it's about $500 an hour.
I mean, I assumed it was cost prohibitive. I'm just
Mhm.
thinking about it.
Oh, for this
I
stuff?
had like
Yeah.
a while ago and the judge was yelling at me because there's like no expert. It's like,
Right.
There's a lot of ways to get around that, though. Leanne Friedman, when I was a younger attorney, a less seasoned attorney, when I had less gray hairs, I sat down with her one day and I was like, teach me this, because not from I don't want to use your services, but there are cases. And I mean, she showed me, you can go on the Bureau of Labor and Statistics and pull up that sort of information. I mean, you can just go online, have your client go online and pull like all of the job postings.
That might be a neat seminar to have, like how
Yeah.
to do that without.
I don't want to teach that one.
But you're so good at it. I mean,
I just
got
ask a
the
lot of
finding,
questions, I
but
think is where it
still,
comes
it was
from, right? Like,
an uncomfortable position to be in
Right.
when, the other party like did not produce
That's a great
discovery and the judge is yelling at you and your client's looking at you, it's uncomfortable.
I mean, in my opinion, that was unprofessional on the judge's part, but
Oh,
that's fine.
she was texting, passing notes, lots of issues.
Okay, well,
The judge was texting? Awesome.
I mean, I have no issue if they're like telling the law clerk that, I need
No,
my
she
cup
was-
of coffee, for example, off the,
She was smiling. She was also
clearly not
writing
paying
notes.
attention to what
She
they're doing.
forgot what exhibit I was on several times. It was,
I'm sorry.
it was a really
That was a
awful
very-
People for that, though. They have people for that. That one thing.
Yeah.
But yes, I agree with you. That would be a great seminar. I wonder if one of the expert witnesses would come. Give
To
that-
give a seminar on how to not use them.
Again, it's limited to like pro bono. It's never going to be an exact science like what they're
Then you would
doing,
be
right?
so impressed by their services
Yeah.
that we would hire them.
I think it's taken.
But, again, it's limited capacity, right? Also, I would,
Brother, you're gonna keep getting it.
I know.
I should be flattered as far as the age goes.
Yeah.
Does anybody have, we are running out of time, so introduction of documents is one of my last things. Does anybody have any questions about this? I find that people really struggle with laying foundation. And I mean, I'm guilty of it in certain types of cases, but if you will look through my trial testimony that I sent, because the place that people get hung up is their witness doesn't know how to answer the question. I asked like the same 5 questions for every exhibit and it becomes just like this canned, like, this is the information I'm looking for. It is in my trial testimony, but does anybody have any questions about this?
Just don't forget to introduce your exhibit, the
Or
number.
move it?
Yeah, that's what I mean.
Yeah, move it.
I meant to say, move it into
Yeah.
evidence. I cannot tell you the number of lawyers that do a beautiful job identifying it, showing the counsel, asking the questions, and then sit down. And if you have a nice judge, they might say something, but if not, I'm surely as opposing counsel, not gonna be like, oh, by the way, you forgot to move it into evidence, so don't forget.
Sometimes the clerk will say, do you want to move this? Or the judge will say, do you want to move this into evidence? And sometimes they don't, and candidly, they probably shouldn't. I also write that in my trial testimony so that I don't forget to do it.
Yeah, everyone.
And I do it as soon as I ask the last foundational questions. Because guess what? The minute I move that document into evidence, I don't have to ask a single question about it anymore. It's lovely.
And if you forget, you got to go back and ask the court to introduce it.
Yeah.
Usually they will.
You'll never remember, because you'll be 7 exhibits away and barely. unless you
Yes,
see it
correct.
Sitting there.
Correct. But
Yeah, that's the
once,
most important thing though,
Yeah.
is getting it into evidence, because it's the easiest thing to overlook.
yeah, but again, from a timing perspective, when we are running out of time, moving documents into evidence, you don't have to, you can just argue from them. People forget this. It's like business records.
What'd you say? I didn't.
You can just argue from them. Once you've moved them into evidence, I don't have to ask any questions anymore. The text messages in evidence, the judge can read them, right? It's their job to read them. They don't need my client to read them verbatim. It's not helpful.
Although sometimes judges will ask you, like, if it's, like 3 or more pages, they may say, what is it about
Then I
this string?
Then I should have asked better foundational questions, in my opinion. Can you, candidly, I should have. I should have laid my foundation better.
Can you leave your evidence that you admitted to evidence? Can you have highlights on it and a few flags and just hand it over? The judge can look at both.
No,
No.
can't be altered in any way.
Okay, so just leave them as is.
Correct.
Okay.
I get away with highlighting
I was gonna say, I could see your smile. I was like.
as long as, well, period. full stop. But, or I'll highlight the opposing counsel's copy the same way.
So you can highlight if you know how to use
It
it.
depends on the judge and the magistrate, I think is the answer to
Mhm.
Thomas's question.
Yeah.
But the problem is if you
Saying, no,
pre-hire.
you're not allowed to, but he does it anyway, as long as he does it and notifies the other party, it's less likely to be a problem.
And I'm gonna play devil's advocate for Thomas. Unless you have another copy, there is a risk that you play with that a judge or a magistrate is not going to let that document come into evidence.
True.
So if you pre-highlight it, I will say, Your Honor, can I approach the witness and direct them to read a specific line instead of highlighting it? But they're just,
Right.
what's it say, different ways to skin a cat or whatever.
But and I like your suggestion of just putting it in once it's in evidence, because the likelihood of an opposing counsel, unless they're very good, or a pro se person cross-examining off of that document when there's been no direct testimony is very small. They
That's
just,
why I like business records too.
so just,
That's why I like business records for the same reason.
Good
The
discussion.
more we have this conversation, the more I'm like, man, I'm cutthroat.
Good discussion.
I'm like, I don't have time for this.
Pieces of
I
information.
don't have time for these games, guys.
I remember you when you weren't.
I learned from you, old man.
Didn't see that one.
All right. So one of the things you need to make sure is that you are asking the witness whether or not it's a fair and accurate or a truthful and accurate copy of the original. And that it was unaltered because you are getting them to testify under oath that they have made no changes to that document. Make sure your witness knows what documents you are putting in front of them before you put them in front of them, okay? If there is an objection as it relates to foundation when you are moving a document, ask the court for the court's indulgence, take a breath, think through it. You can move that document. Sometimes that's enough to throw an attorney off, right? When somebody objects to the foundation that was laid, I guarantee you can get yourself there if you just take a breath and think about it. But again, I write all the foundational questions out. The witness isn't shocked by them. And I've already thought it through so far that objection can't exist anymore. Okay? Go ahead.
Well, I was just watching a hearing where the judge denied a lot of the documents, either saying, no, I don't agree with that hearsay exception, or you haven't really done a good enough job.
That's a foundational. The second one's a foundational issue.
So-
The hearsay is a different objection. Absolutely.
So I'm just wondering if you have any guidance if that happens. I mean, I guess part of it is maybe the attorney hadn't thought through enough.
Yeah, so at the foundational, yes. The hearsay, this is where, so hearsay is a hard one in family law. Because there's so much of it, right? And, there's so much, well, the child told me X,
Right.
right? Or the child's teacher told me Y. There is so much hearsay. But if we as attorneys have done our job ahead of time, that shouldn't exist. If it's something the child teacher said and you don't want to put the child's teacher through that, then you better subpoena whatever documents that teacher has. You better subpoena their communications, get the business record certification, and then that all goes away.
Yeah.
So again, I mean, it's people just, it took me a long time to be able to see that far in advance in a case. So I mean, you have to recognize it early on so that you have time to prepare for it. And so that you are not the week leading up to trial going, oh shit, I need those business records. Guess what? You ain't got time. You ain't got time. Maybe the school will get them to you. The bank, rest assured, they're not getting them to you.
And even if the school does get them to you and the other party wants to object because you didn't get them in a sufficient amount of time.
So.
Yeah, I think it was partly.
Yeah, I mean, it sounds like a little bit of both.
Yeah.
There is absolutely a way to plan for a lot of the hearsay. But the foundational is just somebody didn't think through it ahead of time. And just remember, text messages usually between the parties. So that's not a hearsay issue. It's the third party text messages that become problematic. And then only the statement of the party can come in. So anybody else have any other questions? We talked about some of this. Self-authentication, which is the business records. Public records are not subject to the hearsay rule. It's one of the exceptions. You can also, again, stipulate to things that even have hearsay in it. Want to get creative? Ask them to stipulate to text messages or school communications or whatever the case may be. I'm pretty sure if you asked a family law attorney to stipulate to a list of exhibits ahead of time, they'd be like, are you nuts? Nobody's ever that prepared, right? So, but it's definitely a good tactic to get around some of that. Objections. Just remember, in the state of Maryland, you don't have to explain your objection unless you are asked, meaning give the basis for it.
Oh.
This is why we are not very good at this, guys, because you don't have to explain the basis. But then what happens is everybody is always tripped up as to when a judge asks, what's the basis for your objection? And when you are asked that, you better be able to name all of them. Not just one, not just one. You don't get to say, Your Honor, it's this, and then the judge say, I'm sustaining an objection, and then you'd be like, oh, I have 3 more reasons. You better just lay them all out there and then be prepared to argue them. There's also times in family law, and I'm sure in other types of law, where you have to just note a continuing objection to a line of questions. Again, it's a preserving the record issue. If the witness has already answered, you are not objecting, you are motioning to strike testimony. That is another one that I think we forget.
Yeah. And the continuing objection.
Yep, and the continuing objection.
Yeah, there's a public defender who's really good at that, and she will like in St. Mary's, there's a public defender who, whenever she has trials, like she'll do continuing objections like over and over, and she'll get like tons of evidence thrown out by doing that.
Mm-hmm. I think it's probably the one that most family law attorneys are best at when you are noting a continuing objection to whatever hearsay testimony or like a parent testifying as to what a child said, for example, those sorts of things.
Yeah.
Because technically it's hearsay. The problem is in family law with custody cases, right? The best interest of the child standard always trumps everything. And that's what a lot of judges and magistrates use to get around the hearsay objection.
Mm-hmm.
I don't know if it's accurate or not. I think it's very judge and magistrate specific in my experience, but that's
I would just say know your judge and pay attention to the judge, because sometimes they make a facial expression or they'll say, they almost look at you waiting for the objection or object for you sometimes. So, it just depends on what's going on, and you just have to pay attention to how they're reacting to what's being said.
When you are a trial attorney, there's so many moving parts in the courtroom. You have to watch the judge or the magistrate's body language. You have to watch the party's body language. I mean, I've argued party's body language on the stand in closings before. Yeah. Mm-hmm.
Also, when you do MPLS cases more than other cases, don't read too much into this. I'm not saying anything awful. More of my clients or the opposing parties will claim or are getting disability. And then they sit there and actively participate in a case that goes on for 3 hours, 7 hours, et cetera. And I've had one Baltimore City judge tell me, counsel, I'm taking judicial notice. Your client has participated, has not been in pain, sat up, stood up, walked to the bathroom, came back, passed you notes. I'm not buying it. Well, that's never happening again. But
wow. Yeah. Wow. I won my very first trial in Howard County on that argument. In front of Judge Tucker when he was a new judge. And the case went up on appeal. Yeah. Yeah.
no one likes a faker.
No. Here's just a list of common objections. It will be in the materials. Oh, sorry. Here you go. Know your objections on privilege. Also know the case law on privilege. It is very important as to whether or not a marital therapist that talked to both parties has privilege. It is very important to know whether a mental health therapist for the child has privilege with mom and dad. All right, anybody have any questions other than the ones we've already covered? I did pretty good, only 5 minutes over.
Amazing.
Just holding it.
I double checked. I don't think I got these slides.
That's because I finished them at midnight.
Everybody got the materials, but you will get both slides and a recording after it's done. So yes, sorry, I meant the materials went out. I
didn't finish them until very late last night, guys. I'm sorry.
So I just want to say a huge thank you to Jessica. This is a unbelievable undertaking. She did all 3 sessions, and I would say too, just her willingness to be so generous with her personal materials that are in your materials is just incredibly kind.
Like I said, that better not come back to bite me.
Yes, I agree with that. So Jessica, thank you a million times. So just looking at time, we're here till 12:30. I have 5 after 12. We were gonna give the mentees an opportunity to talk about their cases if they'd like. And then we have just a very small graduation ceremony and thank you and pictures. Hopefully, if everybody's agreeable, if you don't want your picture taken, you're certainly not obligated, but would, oh, yes, you can stop sharing, but I will keep recording.
There you go.
Would any mentee like to share their case, anything that they found interesting, any questions they have, anything they learned? Or just present their case generally and we can talk about it.
I want to hear about everybody's cases. I didn't get to participate in that side.
Well, I got a bit, I'll start because mine will take 2 seconds. I got a very easy case, so I feel like I need to come back and ask
You're
for another.
welcome to.
The client has been separated from her spouse for, I think it's been like 16 years. He lives out of state. And so I think the role wasn't even the hardest thing I had to do was find a process server in that state. And that was just a matter of going on what was it, like the national
Private process servers.
Emailed 5 people to just bargain shop. And then, they served him rather quickly. He didn't respond. I filed a request for an order of default. I got the order of default. The notice of default hasn't been issued yet.
Okay.
But yeah, so I think, hopefully before the summer ends, she'll have her divorce and be able to go on her way.
Awesome.
You must have done a good job. It's not easy to get the request for order of default right the first time. Maybe it's never happened. So it might be the one.
I just used the court form.
That's helpful. They love their own forms.
Yeah, well, no, and I noticed that from
Yes.
other deficiency notices that I've gotten, they'll write a little note. In order to not get this rejected, use the court form.
Yeah, I use the court form now.
So yeah.
Which is the only court form that I will use. I modified everything else, but that one I find, because it is so hard to get an order.
But I was asked for, court emailed me and asked me for a proposed order. To file that ASAP.
Proposed order of default. Okay.
Yeah, so I filed the proposed order and then the next day it was signed.
They didn't automatically issue the notice?
No. I haven't received service of it yet. I'll double check.
Call the clerk.
Frederick, so that's in Frederick County.
Call the clerk, because that feels like an error on the clerk's part, if you want my honest answer.
Well, yeah, I'm gonna
Talk
call.
about Frederick.
Do you want my Frederick County case there?
Does anyone else here work in Frederick County regularly?
Oh, no.
Because
Sarah does.
Sarah's, this is her case. Sarah's case, is it normal for a scheduling conference to be set as soon as a complaint is filed before an answer is due?
Yes.
Some counties are doing that.
Yeah.
Howard County does it sometimes too.
That's insane. So even before an answer.
Yeah, if it's a divorce,
Okay.
Howard does. I don't.
Right.
Yeah, but then if you need to move it, you just email Steve.
Or the party might just show up even if they haven't been served, and then it kind of helps move it along. It's not getting stuck at that.
Yeah.
The counties that actually want to make the time standards, that's what they do. Frederick, they're not even, they're out. They didn't even try.
Well, Tucker has them calling and scheduling your divorce trials as soon as you finish your scheduling conference. And Howard.
Who else would like to share?
I can share my case.
Great.
So I jumped into the case when there was a scheduling conference. The first scheduling conference was already scheduled and both parties showed up. We showed up with the custody agreement. This is just straight custody, not divorce. And the judge went over the terms with the other pro se litigant and he wasn't prepared first time he'd seen the terms. So we got a second conference. He did not show up to that. This was Baltimore County. He did not show up to that. And then Monday he emails me, "We'll talk to your client because she's not following the agreement." Like, we don't have an agreement.
That's the whole purpose.
And so he signed that right after that, which is good. But we're still set for trial for June 12th because he just refuses to provide pay stubs. So it's kind of a moving target because he had one job. I got the pay stubs for that. And then he got a second job. And he hasn't provided for that. And then he had a baby with somebody else. So it's kind of child support guidelines just continue to change. And we can't even subpoena because I don't know where he works. My client doesn't know where he works.
Subpoena him to trial. Subpoena him to trial to bring the documents.
Okay.
Issue a subpoena to take him.
No one knows where he works. Not a friend. Yeah, put the squeeze on him. Someone knows something.
Okay.
Does he know, do you know where he banks?
So I skipped all of discovery.
Ask your client. If your client knows where he banks, subpoena the bank. You can back your way into it. I love documents if nobody knows this.
I'll try that.
I have a
Yes.
question about my case. I'm sorry.
No, yeah, I'm done.
Okay, so in my case, I'm representing a grandmother who wants at least visitation to full custody of her grandson. The case is unique in that Baltimore City Social Services launched a SEMA investigation back in 2013. My client's grandson was hospitalized last year. His father has now assumed care for him. The client first filed for custody several months ago, and that case was thrown out because of service issues. We have the service issue settled, and I've issued a request for documents from Baltimore City Social Services. It's been past the 30-day mark. I have not heard back. I've reached out to the custodian of records, and it's just like radio silence now. So, like, what should I do? Should I file a motion to compel, or like?
You can call their general, like whoever is, I don't know if it's the county, city attorney, whoever represents DSS. Usually I pick up the phone and call them and say, "Hey, I'm sending you a subpoena."
I did that.
And
Who
then,
did
yeah,
you
but usually
serve?
they'll do like a motion for a protective order
Yeah.
or something like that before they release the records to
So I
you.
initially talked to Rawlings at I forget what agency, but once I issued the subpoena, I reached out to the custodian and I guess another attorney that was assigned to things, and I gave them a heads up, and it's still been like crickets.
And you haven't gotten a motion to quash the subpoena yet from them?
No, I haven't.
Sounds like something's, because usually that's like,
Yeah, usually they do that with
Routine.
us.
Yeah, like they have it, they have that ready to go.
I'm wondering. So I guess another question is, how long? Like, is there like a statutory requirement that they hold on to records for like a certain period of time?
no.
Okay.
But if it's
because-
from 2023, you're probably fine.
Okay, because I have like maybe 4 documents from the initial SENA investigation. It says like the case number is pending, and that's literally all I have to go on. So,
Should be triggered by the child's date of birth, I would think.
Yeah, I mean, they keep the records like for forever. I mean, they've switched the systems in which they're maintained, but they can always retrieve
But it does
records.
sound like if you haven't gotten a motion to quash, it would lead me to believe that maybe you served the wrong person or it got stuffed in a drawer somewhere, because it's usually literally rubber stamp. They get it and they send a motion to quash immediately.
Like I've had to send a subpoena like 3 separate times in like Prince George's County, and by the 3rd time.
Oh, they're terrible to try to get anything from that DSS office.
I know that as child counsel in Cinebatters, right? Like, so like not even talking about custody.
Chances that he's gonna get it, and more importantly, that it'll ever come into evidence.
Right, that's the thing, is you're gonna have a hard time, A, getting it, and B, even if you do get some portion of it, getting it into evidence is gonna be a very difficult thing. I would say my best advice is to, and I'm gonna sound like a traveling salesperson, but I really mean this, we are doing this exact topic
as a training on May 27th.
Okay,
And we have Larry Feldman, who's a mentor here, Doris Greenwalker, and a wonderful attorney from OPD, Parental Defense Division. And they're going to be presenting about all of this. And the attorney from the Parental Defense Division, Ashley Edwards, basically said just what Thomas said. They're not going to come in if you even get them, but there are a lot of ways to get that information differently.
Okay.
Are there police reports? Who was involved? Did anybody else witness it that you could call as? So I would just recommend coming to that training because, getting that from DSS and getting it in is going to be pretty difficult.
It was
thank you.
Is it going to be?
12 or 12:30.
It is at 12 on it's on my signature line. It's May 27th at noon. And yes, we will absolutely record it.
And it'll be like an hour or two.
It's an hour and a half, and it's called Children's Statements, Testimony, and In-Camera Interviews. So we're going to be going over the full gamut of, what the law says, and then different strategies and techniques. So I think that'll be super helpful.
Thank you, guys. I appreciate it.
And just a thought, like if there's a best interest attorney or like a child custody evaluator, they have to actually probably get this information and they can do a report that reports on what the report said. It can't get into evidence, but there it is all of a sudden sitting right in front of the judge.
Helpful. Thank you, guys.
So I have a new case and it's very complicated. At least it appears in the little bit I've discussed it. But my client lives in South Carolina and she wants alimony and does not want to pay child support. And the thing that I'm kind of struggling with right now, and maybe it would be helpful to have ideas. Oh, and she's also on disability. So I know there's some issues about checking which kind of disability she has. But one thing that is kind of bothering me right now is that she's had a history of domestic violence. And yet I was also listening to you about, trauma. So I feel like I need to get a better grounding in really what is her story about the domestic violence to really get a sense of whether or not she really has a case for alimony. And also there's some risk, it would seem, if she goes for alimony and they decides that she should pay child support as well.
Well, that will happen.
It will, yeah.
Yeah, so I don't know if anyone has any suggestions about this whole thing with alimony. You had mentioned during the discussion today, this idea that sometimes you'll say, I'm doing this against my, you're going forward with this against my advice. But right now, I'm really not feeling a comfort level about the alimony, especially since the latest thing was her spending 6 months in jail for violence against her husband.
Oh, so she was the perpetrator of the domestic violence, not the victim of.
Well, she says she was the victim and that's why, but she's also a perpetrator. And then another time she got caught.
Which is why she can't work, which is why she has a need for alimony.
But alternatively, also,
Inability to work.
is this the mother of, she was the perpetrator against the father of the child in question for child support?
Yes.
Okay.
And she also has.
Yeah, it may not be a great cohort case as we discovered.
Yeah, that's what I'm not, I have.
No, it's awesome. Let's all do it together.
I need everybody to help.
I don't know why you make this argument.
What jurisdiction is it?
Where is it?
It's in Baltimore City. And the other thing is she also had some history where I don't know if she exactly lost custody of her older child, but
This
her
is getting
mother-
worse and worse as every word comes out of your mouth.
This is it. Her mother has kinship of the daughter and she doesn't take care, hasn't taken.
Is there counsel on the other side?
Earlier comment.
Not yet.
Yeah.
Just, okay.
So,
Who's your mentee, your mentor?
Jonathan.
Help you.
I was gonna say,
The three of us can.
yeah.
I mean,
This-
or
this is
four,
not-
right, whoever, I'm just.
There you go. You agree?
All of us- This is a hard case. This is a hard.
I wasn't really sure, we did talk about whether or not it's an appropriate case.
No.
Yeah.
And the other thing is you
piece.
mentioned, is there some advantage of her going through South Carolina as opposed to Maryland? I can't really answer
But the
that.
kids
Well, but
are
the
here.
child is here and the
But
husband is here
there's
and the
no,
divorce.
that's not, she's not looking for custody.
She
But
just
she's
wants
still-
alimony.
But he may, she just wants the divorce,
But the
so.
divorce,
They're
the
really
grounds
into
for
fault
divorce,
in South Carolina.
the grounds for divorce happen here presumably. I don't know
Yes,
that
I
she
think they
qualifies to
did.
be a South Carolina case.
Okay,
That we don't know, but did you talk to her about calling? She's gonna check in with South Carolina to try to make a decision, the client.
well, I wasn't sure about that part of it, but, because I'm not sure how much
Front.
I can really.
Tell her
Just try
South
to make a
Carolina is the
decision.
perfect place because you're not barred there, so somebody else will handle this.
Yeah,
Everybody deserves representation.
Yes, that's right.
Sometimes the representation should not be me.
That's
The second part of that.
I just kind of have this vision of the alimony exploding everything. Because
Yes.
he's very hateful towards her and she's clearly very hateful towards him.
Exploding
Right.
what exactly?
Exploding.
I know, exploding her case? No, I think the incarceration did.
Exploding
Oh,
the anger and the vitriol.
Yeah, that's typical.
Yeah,
Could
okay.
have been the fact that she assaulted him also.
It's expected.
Yeah.
No, that's right. But somehow she
Well,
was
we
caught.
don't know. What she, I think, says that there's been a history of domestic violence, so toward her as well.
Probably.
So it is very complicated. And perhaps
That's a
not
hard
a
one because I
cohort
think you're
case.
gonna run into a judge that's gonna say this has been adjudicated and therefore you are the precipitator of this domestic
Mhm.
violence.
That's why-
Oh, certainly on that issue,
And,
yes.
and so I
That's a
think
good point.
she is going to, if what you are saying is accurate, and I'm not saying it's not,
No,
but I think from a perception perspective, she is going to
Yeah.
struggle.
That's where I was
yes,
coming from.
definitely.
That's what I was thinking too.
And I
Although
think
we can be
that-
trauma informed and there may be some issues that if
Oh,
she
yeah.
didn't
Mhm.
have proper representation or she didn't
Oh,
advocate
correct.
for herself. and
Absolutely.
That's how she ended up in jail and.
Oh, absolutely. However, I think when you think about her presentation to the court,
Right.
I think that needs to be some of the conversation with her.
Oh,
And or
100%.
what are you doing to mitigate
How
When
some
it's
of this?
marriage?
18 years.
Does he have the ability to pay?
Yeah, he apparently, according to her,
Right, that's, I mean, but like, yeah.
yeah, that he makes a good living,
What's that? A good living being
Yeah.
what?
100,000.
And one
be a
child or
little-
more than one child?
Well, he has custody of the one child. The other child is
Grandma.
17 and is in kinship with the grandmother.
But is not his, right?
It is his.
Oh, both the children are his. Okay.
What does it mean when they say internship?
Kinship?
Yes.
Somebody else in the family is caring for a child.
Right,
Not the
and what
parents.
we think happened is that,
Should
which
care.
further complicates and gives her a real uphill battle, is we think DSS placed the child out of state with the grandmother in South Carolina. So if there was DSS involvement, then
Well, that's where you would
But
hear the word
alternatively, that
kinship
also
care.
means the dad was incapable of
Yeah.
caring for
yes,
his child. So
exactly.
the other side of that coin is actually supportive of her position.
Right,
Yeah,
good
what
point.
Maryland case law though says, a parent's ability to care for one child.
Oh, I don't
The-
disagree with that.
you know.
I don't disagree with that.
Anyway,
Regardless of
I
what.
guess we'll,
Well,
Yeah, yeah,
I think
yeah,
we're
yeah.
gonna have to have a big powwow, so,
Okay.
on that. So
it's
anyway,
not one of those other simple cases.
Yeah, sorry, I hit the jackpot.
Can I say something?
of course.
Okay, thank you so much. I'd like to really extend my appreciation for the program. I'm fortunate enough to not be yet admitted in Maryland and be part of this program. Initially, I thought like this will be great for, fresh graduate, but I see how it's really benefiting others who's been in other areas of practice. And it has been such a great opportunity in the learning curve. I've learned a lot from Attorney Curtis Cooper, who's been extremely patient. Really learned a lot of professionalism from him. Have attended a custody settlement conference with him in Baltimore County about 2 weeks ago. A really kind of a hard client to deal with, and I see how he handled it. I thought I've seen no really, hard clients, but that client was so unbelievably hard and refused to understand what has been told to him. If you tell him something 10 times, unless he refused to understand it anyways, but I know he understood what Curtis was saying. And again, it's been a pleasure, and I've seen, I'm from a different system. I'm originally from Ethiopia. I've practiced a little bit of family law there. I thought I would come here and rock. But the whole thing is common law system, civil law system. This is a really good curve, and Jessica introduced me to one of a really seasoned lawyer, and I've practiced with her as a law clerk for about 6 months, and I've learned a tremendous amount of knowledge. And yeah, this networking in general has helped me a lot in this process.
Who have you been working with, or who were you with?
Tarsha Harris?
Yeah.
Seasoned, and I've learned a lot of good things from that experience, but now I'm preparing for the bar. Okay, so when I say I learned a lot of things, it can be from a different perspective, but yes, I learned what to do good, what to not do, what to do and what to not do in this kind of family law practice. So thank you so much. I really appreciate it. And I'm taking the bar in July.
Good luck.
Yeah.
If anybody needs an associate, she would be a lovely associate.
So thank you so much. And yeah, I'm excited about this opportunity.
Awesome.
Thank you. Thank you, Jennifer.
You're so
Also.
welcome. And on that note, let me give you your certificate and your MBLS pin. And this is a little something for your mentor.
Yes.
Can I take my children's agendas and forward all of them?
I just want to tell people in wrapping up, we also have a May 21st virtual training, understanding how implicit bias impacts advocacy and addressing it through a trauma-informed lens. I will be giving that along with Heather Hyman, who runs our human trafficking prevention program. I just want to remind you about the pro bono portal. You can go on there and see all kinds of cases that need you, and that is in your materials. Somebody had asked when we did our initial survey if we could gather a document about how to grow your family law practice. So Mujin, who was here, put together an excellent and long document in your materials about how to grow your family law practice. And for those of you who need trial practice, the Public Defender's Office, the Parental Defense Division, they need panel attorneys, because if a child comes into the system and both parents need an attorney, the public defender cannot represent both parents because it's a conflict. So they refer out to panel attorneys, and it is an awesome opportunity to get a lot of experience and really learn how to advocate, and they train you and they will also pay you for your time. So that application is in your folder too. Yes.
A couple things. Every once in a while, I decide I don't have enough on my plate and I go on the pro bono portal, and then I email Jen and say, I don't know how to do this kind of law. Can somebody mentor me? So they will find you a mentor in another area of practice if you have any interest. So there is that component.
Awesome. Thank you.
The other component I have recently learned is that the Pro Bono Resource Center, who often does a lot of expense and fee reimbursements, will reimburse the cost for Quadros. It is one of the specifically delineated services that they will reimburse for. And I'm happy to help if anybody needs help with that.
Yes, and definitely that's in your materials too. They reimburse for a number of things and even things that aren't listed. So make sure that you do that. We don't expect you to lay out a bunch of money because you're helping somebody, and you also don't need to. So here is our certificate for Edith.
And a little thank you.
Spend of like
Sarah.
$10.
You're welcome.
Yeah. I really think that. I'd let $10 go.
But the other
We've got
Maybe 25.
Yvonne
$600.
and Michelle.
You are here, you are. Thank you very much. That's for you. And Michelle.
Just knowing that the payment would be right there.
Thank you. And then we've got Heather, whose mentor could not be here today because he is in a workers' comp hearing. That is Larry, but Heather, here you go. And thank you for participating.
Thank you, appreciate it. Thank you so much.
Welcome, sure. And then we have Sarah and Erica right here. And Sarah. Yay, Sarah, and yay, Erica. Erica. Thank you so much. You're welcome. Actually, it's quite a nice MBLS mug, so I hope you like it. Kenneth and Allison could not be here today, but isn't that nice?
Very nice.
Okay.
Thank you so much.
Thank you so much. And then we've got, let's see, Lucilia and Carrie, but Carrie couldn't be here today either, but she's here in spirit. Congratulations. Then let's see, Diana and Rich. Thank you. You are, thank you. And Rich, thank you so much.
Sure, thank you.
You're welcome. And let's see here. Ginger and Jonathan could not be here, but we will give this to Ginger nevertheless. And Thomas, last but not least, of course, his mentee could not be here. She is either here virtually or going to catch up. That's Nazish, and that is for Thomas. Jessica, Major,
Thank you. I hope all the mentors will come back because I'm teaching again next year, guys.
Yes, I hope they will too. And I'm going to send a survey out to mentees and mentors, and I really hope you'll give feedback because we're always looking to improve. Did you want to say something, Curtis?
Oh, yeah. I put out by email that there's a restaurant up the street called the Kaz